petitioner, I'm mentioning item number 26. We'll need, my lord, 2 weeks further time to get the instruction, my lord.
You take the request of the council for the response.
Item 26, my lord.
Submitted from the council. Petitioner has
May I please your, my lord. I beg to mention the matter of item, writ petition civil case number 5589/2020, which was lastly posted on 19/1/2024. Kindly listed the matter on 29/6/2024, 29th of June.
let
If
it be
possible.
on July. In July.
Kindly fix one date
In July. We'll have
after
it in July. On 19 July.
March, please.
Please, Lordship. I beg to mention item number 6, Lordship. Kindly adjourn for today, Lordship, and list on Monday, Lordship.
Item 6
Item
adjourned to be listed after.
Lordship, kindly motion matter, Lordship.
Why today? Why?
Lordship, Mr. Yazid Ahmed is unwell, Lordship. He asked me to adjourn this, Lordship. And fixed on Monday, Lordship, next Monday, Lordship.
Monday,
Monday, Lordship,
26.
26, Lordship.
All right, 26.
Wait,
Yes.
please, my lord. I beg to mention one matter, my lord. Item 18 for requisition. We have filed one affidavit in reply, my lord. The
Item,
18, 1818, my lord. The Kamakya corridor case, my lord.
Ah.
Prayer for requisition of the same, my lord.
yes.
Highly obliged, my lord.
May it please your Lordship, with due consent of the other side, I beg to mention item number 35 to 39 of the daily list, my lord. Some time may be granted to us to file our affidavit in opposition, my lord.
Yes.
I'm a petitioner, sir.
The request of Mr. H. Purwala. Matter says adjourned. 35 to
39, my lord.
39. Listed after
Highly obliged.
May I please your lordship? May I please your lordship? Lordship, with the consent of other side, I beg to mention item number 33, lordship. Lordship, I am appearing for respondent number 4. Lordship, we need some time to file our affidavit in opposition.
Who's for the petitioner?
Your Lordship, I am appearing on behalf of Mr. T. Dury.
Any objection?
No, Your Lordship.
Item 33 at the request of the council.
You Ghosh on behalf of DP Bora, Lord.
We have 4. Matter says adjourned for
4 weeks.
4.
Much
Bless,
obliged.
May I please, Lordship. I beg to mention for listing of a case, my lord, quantum case, my lord. In the next week, my lord, 24th of this month,
26.
my lord.
Lordship, item number 30. I need to file a affidavit in reply.
4 weeks.
Lordship, 2 weeks. 2 weeks. I'll file within 7 days.
At the request of Mr. F. 3 weeks. Link to file reply.
May I please, your Lordship. I am paying for one matter for withdrawal of listing on tomorrow, Lordship.
Tomorrow.
Lordship, withdrawal.
Yes.
Deeply obliged.
May it please your lordship. Lordship, I beg for listing of a writ petition. We have filed an IA relating to amendment. Lordship, may fix any date by next week. In the motion column, Lordship.
No, if you file, it will come for order. IA for amendment,
Yes, Lord.
26.
Obliged.
Yes.
Your Lordship, as per instructions from the petitioner, I pray to withdraw this matter, Your
The
Lordship,
request
with
of
leave.
council. Your name?
S. Newar.
Name or name. With the petitioner. On withdrawal, in order, they may be pending either
In case, my lord, my mutation proceeding has not been dealt with, my lord. Instruction has been sought.
Not received. We have not received instruction, Lord.
Next week, Monday, possible.
not Monday. It has to be after vacation.
My lord, prior to that, possible, my attempt may be made. Only instruction required, my other, it is possible to dispose of.
Why we want to keep it after vacation?
Look.
Further instruction, further time of work. To complete instruction. Sit after.
My lord,
the month of
only pray for date, man.
it's not 19th July.
Deeply.
The summary I appeal to the
Lordship, in this matter, we have been asked to take instruction why the case hasn't been registered. So we have got the detailed instructions, a copy of which has been served upon.
tell us why, what is the
So in fact, the order of the Boko judicial magistrate case, that was misplaced. Finally, it has been traced out and accordingly, the case has been registered. So that case, Boko police station case has been registered and case number has also been detailed here. And the investigation is on.
so it is registered?
My lord, if it is registered, then I have no grievance, my lord, but that was the only grievance, but my only limited prayer would be, my lord. If it is honorable court is pleased to grant my one prayer, that is, that my lord, the matter may kindly investigated by respondent number 3, my lord, or any other officer other than the OC, my lord, officer in charge of Boko PS. Because on earlier occasions also, there are instances that after registering the case, my lord, they were forcing the complainant to compromise the matter with the respondents, private respondents.
So who is now, it is by somebody else,
Different. Riju Mani.
this is in charge of Santoli OP.
See, that is the outpost, my lord.
They are
And my grievance was against both the out,
you go to the, why don't you share a copy of the instruction?
Riju Mani in charge. It is a different office.
It's Purwal, it's for the communication received from the inspector in charge, officer in charge. Very details mentioned that the copy of the order dated 8/12/2023 passed in CR/49/2023 passed by the Judicial Magistrate Pratika Boko. It was sent to the Boko police station. Was displaced from after thorough search. Copy was found on 18/6/2024 and the case has been registered on the basis of the order of Court of KMF. And the is registered as Boko PS case number 12 under section 12. The officer who has been entrusted to investigate is also mentioned in the state of right. Court. The prevent the rest. He responded the directive execution investigation and carrying the investigation and then by the report.
Obliged. Obliged.
May it please your lordship, similar matter has been dismissed by this honorable judge. Dada,
Lordship, matter is almost similar, but not the same.
What is the matter? Tell.
Lordship, petitioner is the city bus owner. And page number 13, annexure 2. Lordship, there is a fine imposed by the DTO Kamrup regarding the violation of 190/2 and 192A. And Lordship, annexure 2, there is a some part. First is the penalty, fine.
second is the seizure of vehicle, and third is the legality of the section 190 and 192A.
Yes.
Lordship, initially 190 of within bracket 2 for violation of noise, violating air and noise pollution. May I read 190? Lordship?
Yeah.
Using vehicle unsafe condition, 190. 190 within bracket 2. Any person who drives or causes or allows to be driven any public place a motor vehicle which is violates the standard prescribed in relation to the road safety control, noise, air pollution shall be punishable with the first offense with the imprisonment for a term which may extend to 3 months or may extend to 10,000 rupees, or with both shall be disqualified for the holding license for the period of 3 months. Now, Lordship, 192. There is a under procedure that vehicle is there is a as per enforcement department there is a one horn is fixed with this vehicle, but whether this horn was
What horn?
operational or not, this
What horn?
yes, noise pollution 190 for which is 13 2.1 192 for violation of noise pollution. Or vehicle was seized for a horn which was annexed with the vehicle, but it is operation or not operation, it is not mentioned here.
Where is that, Alan?
Tunnel is space 13.
The vehicle was, it was fined for what purpose?
It was for violation of the permit condition, my lord. And the order of this honorable court,
What is the total amount?
total amount,
20,000.
20,000.
my lord, the order that I have placed before this honorable court, my lord may kindly have a look the relevant paragraph 10. Why this honorable court has dismissed these petitions. Paragraph 10, my lord.
Is there any appellate forum?
Yes, my lord.
What is the appellate forum?
Lordship, it is the Ministry of Road Transport and Highways, my lord. There is a grievance redressal portal, my lord. The petitioner have to apply here if there is any grievance.
Lordship, that part is under aspect, but we are on the
Paragraph 10, my lord.
Yeah.
May I read, my lord? A perusal of the challan clearly showed that the petitioner imposed the relatable to violation of the terms and conditions of the bus permit. Doors of the buses can be opened only at bus stops. As such, picking up passengers by opening doors at places other than bus stop is a violation of the terms and conditions of 4 number of bus permit. Though the petitioner has tried to make out a case that challenge made to the scheme of the offering the diesel buses by the state government was the reason for issuance of the challan to the petitioner, the court is of the view that said issue raised by the petitioner pertains to disputed question of fact and as such cannot be decided by the report. Factual dispute requiring recording of evidence may have to be decided before a civil court. Further, as there is an alternative remedy available which can be availed of by the petitioners by filing an appeal before the grievance redressal system in the portal opened by the Ministry of Road Transport Department and Highways. This court is of the view that the petitioner would have to avail the alternative remedy available to deal with the challenge involving disputed questions of fact in a writ proceeding is not appropriate. In view of the reasons stated above, the writ petition stand dismissed as there is an alternative remedy available. And my learned senior was the petitioner in those cases. He was the petitioner counsel.
Lordship, that part is
What
right.
has happened to this writ petition 550? Annexed 4 to your writ petition? 550, what is the status?
It's become influence was almost, my lord. Because
No.
though this honorable court has stayed the
recently
off-putting
they-
of the diesel buses, because we have not issued any notice to the petitioners association, individual petitioners. After this, liberty has been given to us by this honorable court, and we have issued personal notice to the bus owners, and in the meantime, some of the bus owner has already routed their vehicles. So this matter become infrastructure.
No, Lordship. 550 is recently they have filed under additional affidavit. And secondly, court has granted liberty to file prepare the law rule as per the law. And as per law, we have to call. And when we have send notice, we reply them. But they are not responding to our reply. They have forcefully reduced the buses and impose on.
This challenge is not related to those cases, my lord.
Where is the notification to take off the diesel buses? You are
Lordship,
not
it
changing
is-
this.
It is on 28/12/2023.
Is it under challenge in this writ petition?
No, lordship.
Then?
They only challenge the challan, and this honorable court has already dismissed similar matters.
This order has been passed
Yes, my lord.
in similar matters then.
Yes, my lord. He was the petitioner counsel in those cases also. That day he agreed to the honorable High Court direction. Now today is disputed. So such an order may be passed. What is this matter?
If our basic grievance is the whether the DTO has the authority to issue permits like permits and the permit condition under 193A. This is our basic grievance.
What is the prayer here? The petition. Lordship, prayer is page 9, my lord. Page 9 is the prayer of the writ petition.
Lordship, second part, pending disposal of the petition, operation of the challan dated 31/5/24 may be stayed and withdrawn and cancelled and allow the petitioner.
You are not raising this issue of.
Yes, my lord.
the DTO. You're only agreeing with the release of the vehicle.
Yes.
So you file your appeal. Whatever is there.
Yes.
Okay.
There is an appellate forum.
Yes, my lord. Disputed dismal forum, my lord.
But then it comes to part. Seizure of the. Owned by the. Or related value. Not of the department. Okay. And counsel. For the respondent, notification for the board. You want. Dated so. Ask it the 53039. Board. We take that as a by coordinate file an appeal before the Advanced Redressal System portal opened by the Ministry of Food and that the petitioner is similarly petitioner is similarly therefore the similar orders the part. Mr. Sharma also actually calculated that in the back that power the size of the DQ. However, there is something that there is an alternative remedy and the petition is both of by this court by the order dated by past in the 3039 and the answer 3039 and present petition are civil. According the petition staff without commenting the merits of the case, relegating the petition by an appeal, statutory appeal, they could be available before the what?
Ministry of Road Transport and Highways, the portal, grievance portal.
Runs represents the portal by the Ministry of Road Transport. The appeal be filed within the prescribed period, if any. And even the appeal is filed, the authority is concerned will pass a reasoned order disposing of the appeal within.
Highly obliged.
My name may be recorded for the private respondent.
Mr. P. Monroe appears for respondent.
Respondent number 5.
Lordship, I am for the transport department.
And for a transport.
Deeply obliged, my lord.
May I please, my lord, this case relates to that, my lord, the petitioner has purchased, my lord, insurance policy, my lord, and he died subsequently, my lord, after making payment sometime, and he died, my lord, which was been rejected, my lord, when we made a claim, that has been rejected, my lord, that your lordship will see at page page 47, my lord.
Have you filed before the ombudsman?
Yes, my lord. That is also put under challenge, my lord, that your lordship will see at page 60, my lord. Now, my lord, what happened, my lord? Even ombudsman also, my lord, discarded our claim, my lord. Operative part at page 62, my lord. My lord, and
Challenge the order passed by the insurance. Order dated 30. Anyone for the respondent?
no, my lord.
Steps. All the respondents. Right in. Report. Be listed up.
Well, in the meantime, my lord, the impugn order has to be stayed, my lord, otherwise they will come for recovery also. And there is a judgment also apex court, my lord.
Till the next return of visit. No court. Order dated going to pass by insurance. And to be listed again. 29.
My lord, both the impugn order. There is a two impugn, my lord, O and published.
Yes.
My lord.
But here, my lord, this case is that in earlier petition, my lord, disposed of page 65, the demarcation of 205 and 202. My lord, page 35, my lord, first in 2012, my lord, the petitioner's land, he was the owner of the land covered by DAG number 205. But when his name was deleted from the revenue record in 2009, resettlement operation, then he applied for demarcation. And the LR staff said that this land belongs to private respondent, it's covered by 2335 and it is derived from 202. Then he applied for demarcation and the stay was granted. After that, both the writ petition filed by the respondent and petitioner was disposed of page 65 with direction that demarcation should be done, and the interim order is, but page 65, page 71 is the direction, my lord. Dispute is that they claim projected that their land is, our land is 205, it is their land. So demarcation is allowed with the direction that both the parties should. Then, my lord, what happened? The notice is granted. A notice is issued, page 73, my lord. Both the parties to appear with the documents, but that is not concluded. Logical and not concluded. Man, in the meantime, my lord, they started construction expeditiously in our land, and there is a complaint on page 82 that the district commissioner has issued a direction to GMC and GMDA till the demarcation
the construction should not be done on 205, but he avoided 202. As a result, my lord, now the construction is going on. So without demarcation, if it is going on, then in future when there will be some problem. That is why our limited prayer is that the 205 should be included in that direction, and expeditiously it should be done, because February to August is that time. My lord. Otherwise, he will be prejudiced.
What was the direction of the court?
Court direction was that my lord, page 72, my lord. Writ petitioner of 5549, that is the private respondent. They are belong to 202. Their land should be 202 and our is 205. So it should be kept in mind. So demarcation should be done both 202 and 205. Now they are not doing, the 202 is not brought in the purview. And natural features of our land will be, will be changed, man. So demarcation, till demarcation will be done, man. Some protection will. Only 202 also mentioned in the deputy commissioner may, and they also demand.
When was the order passed?
My lord, 17 to 24, page 65.
6 months means by August.
Yes, my lord. They with work putting covered to vacant. So that is why the urgency is their nature feature should be changed by that time, and they delaying the matter. That is why we urgently file this petition. DMD says that 202 is not mentioned in the deputy commissioner, district commissioner's order, so we cannot do it. So
When
without
is the district commissioner's order?
my lord, page 82, my lord. Complaint is given, he only mentioned 202.
Yes, Mr. Purwan.
So the court's order are very clear. In the last paragraph, it is mentioned that the disputed land is with regard to two different dams, 205 and 202. Now here, even though the deputy commissioner has referred to 205 old, so here with reference to this particular two cases, the deputy commissioner has written to the CEO GMDA not to carry out, not to allow any construction activities. So unless and until the petitioner obtains a permission from the authority, and that would be based off after the demarcation is.
One says that 202 is not mentioned.
So maybe that may be a mistake, because ultimately the order has been referred to in the order. This particular letter, which has been officially addressed by the deputy commissioner to the CEO, the date 22/3/2024, these two writ petitions has been mentioned, and the orders are
So don't, to ensure that the nature of the land is not changed till the process is completed. This process is carried out upon directions by the court. The court's order, there is a clear mention of these two ducts.
two ducts.
But in the letter, consequential letter, that one duct is missing. You get your instruction.
And at the same time, in fact, the GMDA and GMC ought to have been a party here. because he is enclosing this document where they have been addressed not to take any actions. So,
The district commissioner is the authority.
no, district commissioner is the authority, but deputy commissioner has already addressed to the concerned authority who takes care of the construction activity.
You get instructions.
I will have my instructions.
When? 26?
Yes.
By 26?
Yes, sir.
Okay, but
Construction.
ensure that there is some positive instruction
Yes,
are
definitely.
available as to what is the status
Of the
regarding
demarcation.
that demarcation. Yes. Hard learner council. The petitioner, the respondents, coming down. Lines. The direction. Steps taken with respect to the compliance. Direction. Dated the order it is at- by the revenue authority. That the instructions be placed before the court by 26th of June. As to whether the steps directed to be taken by this court by the order dated to pass the law has been undertaken by the DC in terms of the state direction. So, right, direction of this court directing the revenue authority to take necessary steps in respect of tax number 05 and 02 has been undertaken by the DC. So, let the matter be listed on to date. The extra copies of the writ petition be furnished from the government council within the course of the day.
Yes.
In the course of the day, it became dated by- depending on instruction for the court under order. You are appearing for
I have to respond for one Lordship, so we can take 30 copy as a tab to add. One copy.
the other again. As Purva. Copies on the respondent 1, 3. It's our in the course of the day.
That observation is no. That
On
the
26th.
yes, yes. Observe.
Wait, Mr. Doctor. Lord, this petition filed, my lord, claiming compensation and Zirat, my lord. My land was acquired in the year of 2001 and 2, my lord. Lordship, page number.
Why
My
you
lord,
come now?
18.
Why you
My
come
lord,
now?
thereafter, I have time to time filing representation in the year
You keep filing
2013
representation.
also,
Why
my
have you
lord.
come to court now?
My lord, in the year 2013, my lord, finally, in the year 2013, they also filed notification, my lord.
Mr. Purva, please find out if the representation is disposed of. Page 53.
2014.
Your representation is not disposed of.
No, my lord.
This is 2014.
My lord.
Page 53.
Yes. My lord, no 20, not my lord.
Original page to control. Original.
Belonging to the petitioner.
Uh,
Quite
Where is the
common.
original page?
That may be 2024 maybe, my lord.
Huh?
It may be 2024, my lord.
I don't know, you have written it.
Yes, my lord.
Submit that.
But lordship, the original,
File. The order.
original.
In respect of.
Yep.
Stated to have been filed.
Yes,
By the interpretation.
But original to copy.
As the
This is the type copy.
53.
If any such.
Representation, my lord.
If the
Representation original to copy.
uh,
Xerox copy to
the
copy.
order, it plays with the court. Along with instructions and whether the copy with the matter being
Lordship,
24th of July,
lordship,
steps the petitioner with copies of said petition served on the council to the respondents to obtain instructions within a period of 1 week.
lordship, even though the petitioner has enclosed this as an Annex 11, this is a type copy. He hasn't enclosed the
Find out.
Xerox copy because
Find out.
ultimately
If it is
there
there
has
or
to be
not, you
acknowledged.
find out and get back to us. That's what we are
But
saying.
the petitioner ought to have enclosed the original copy along with the type copy. That is the procedure.
You have to just find out whether any such representation was filed. So, and what orders, if any, are passed by the authority. Let us know.
May please, your lordship.
Yes.
This is the third petition of the Akbar before this honorable court, my lord, pertaining to the Dokonia grazing reserve, my lord. Then the my lord, this Dokonia grazing reserve was declared in the year 1935 at the base of the honorable Design Chief Minister, Bishop District of Medi, my lord. That this the petition, the members of the petitioner committee, my lord, they were enjoying this petition, my lord, without any obstruction, my lord. But what happened, my lord? The pursuant to this order, the judgment order passed by this honorable court in the earlier writ petition, my lord. There is a second writ petition which you will lordship find at page. No. Annex 8, my lord. This is a judgment passed whereby the deputy commissioner Kamrup Guwahati was directed for eviction of the encroachers, my lord, who are encroaching upon the grazing reserve, my lord. And pursuant to this judgment order passed by this honorable court at long last, the circle officer, the Hazur Revenue Circle, evicted the encroachers sometime in the month of November 2017, my lord. Thereafter, there has been any obstruction, my lord, in enjoying this grazing reserve, my lord. But since 2021, my lord, some other encroachers, they encroach upon this land, my lord, the grazing land, for which the committee, they submitted a representation before the circle officer, not only the circle officer, the deputy commissioner, Kamrup, Amingam, my lord, for drawing up necessary proceeding for eviction of the encroachers. But they are sitting over the matter without doing anything, my lord. But what is the question of encroaching upon this grazing reserve? Nobody can encroach upon this grazing reserve without any permission from the authority concerned, my lord. Only my grievance before this honorable court, when there's some representation made before the authority concerned, it is the bounden duty on the part of the authority concerned to raise this encroachment case, my lord, for eviction of these encroachers. But they are sitting over the matter, my lord. Both the circle officer as well as the learned deputy commissioner, the Kamrup Amingam, my lord. Yes, sir. From the photographs we have annexed in the petition that we will also find at page 62, my lord. This is the photograph, my lord. How this grazing reserves are encroached on by some encroachers, my lord. They are actually mostly they are Bangladeshi people, my lord. They are encroaching upon this with this grazing reserve. As a result of which not only the members of this committee, petition committee, my lord, the other.
Have you lodged the complaint before the?
Yes, my lord. That is my lord. That you will also be fine. Page 56, my lord.
In 21.
56, my lord.
Yes.
This is the before the deputy commissioner, Amingam, my lord. that is dated 29/10/2021, my lord. Then before the circle officer also, my lord, that is, will find at page 59, my lord, annex 10, my lord. That is the complete dated 3/4/2023, my lord. Therefore, even if, in spite of receipt of this, to repetition from the member, from the committee on the petition committee, my lord. Yes,
Let us find out what.
my lord,
steps
let,
have been taken.
at this stage, my lord, there have been notice, my lord.
Empty, my lord.
The periods of going to grazing reserve.
Dokonia grazing reserve.
They got that. Dokonia grazing reserve. And it occupied by right. Thereby preventing the citizen resident of the victim illegally land, grazing reserve land. The Dokonia grazing earlier legal occupants were evicted by the government. However, resident seen in the reserve thereby they make no restraining the rights of the grazing land. Representatives of the right before the authority. And SPR also it is what
234.
234.
Okay.
After that, the required by the next returnable date.
Published to me.
Yes.
Mr. Lordship, my lord, in this petition related to non-payment of compensation amount and not adopted of legal land estate procedure to the my lord, this land was acquired by the petitioner's land in the year 2008-9, my lord. And
Who's for the respondent? Water resources.
okay.
Please obtain instructions here.
No, lordship.
Please obtain your instructions
Yes,
here.
lordship.
Council, you have to give us not letting go. Give compensation. The petition. Directing the embankment. Let the respondent council. MS, what is your name?
A Lodha,
A Lodha, hearing for
responding 1 and 4.
1 and 4.
Yes, lordship.
As well as and who's for finance?
I am Bala, your lordship, from stage Chalega.
RM?
Balwa, your lordship.
Okay. Standing council, we publish. Committed. in a period of 1 year. And to be listed in the month of, in the 4th week of July.
Oblige your lordship.
Yeah.
With the Friday market laws. There is an agreement, lordship, deed of agreement between the petitioner and the lordship Villa Parishad. And subsequently that petition, that deed of agreement was cancelled without hearing me, lordship. That's why I'm limited prayer, lord.
Come again?
That deed of agreement was cancelled, lord. Lordship will find a cancellation order at page, lordship, 39. Page 39.
So why don't you file an appeal before the competent?
My lord, that's what.
You file an appeal because there are appellate authority. Go and file an appeal. Why we come before this court straight away?
Section 137 of the Panchayat Act, my lord. He has the right to appeal before the commission.
File appeal.
The commissioner may dispose it of within a related time as my lord directs.
You're withdrawing this petition?
I will do it.
Third learning council of the party. Petitioner is aggrieved by cancellation of the deed of agreement or settlement of market
Market.
in which settlement of market where?
Lordship, Takimari Hat, lordship.
South Salmara Revenue Circle.
Takimari area, Revenue Village, Takimari and the south. Since there is an appellate, alternative appellate remedy available under the statute, the section
137
137
Assam Panchayat Act.
the Assam exhaust the statutory alternative.
Lordship, with a liberty, lordship. With a liberty.
Needless to say, if the petitioner is still agreed, he grant the liberty.
Right. This is regarding victim compensation, my lord. My lord, come to page 37, my lord. By order dated 25. Page 37. As per, my lord, notification issued by the government, my lord, the respondent ought to have paid an amount of rupees 5 lakh, but paid only, my lord, 1,25,000 as interim compensation, my lord. Thereafter, my lord, the petitioner filed petition for payment of rest of the amount, my lord, but
Yes.
have to have my instruction.
Anything to submit?
Everything is DLSA. Similarly situated matter already disposed of by the another court, my lord. Case to case difference.
Case will be different because of the DLSA will have to verify the claim, so perhaps. But let us give us one opportunity of verifying the documents. Perhaps on the next occasion, if we are able to get instructions, then this similar order may be passed.
Let them first verify.
Which
Third learning council. 5 lakhs. scheme. Of the concerned real estate is about or critical every balance amount of vote let the respondents update their Mr. S. Barua appears for
1, 4, and 5.
4, and 5.
3 Your Lordship.
As far as normally so the 3. And let the respondents update their 4. And in the next in order related the respondents to pay their respective extra copies be furnished within the period of this week.
My lord.
Matter be listed again on 22nd of July.
Okay.
Well,
My lord, the petitioner is the absolute owners of a plot of land, my lord, under city board of revenue circle. Page number 60 is the Ramabandi copy, my lord. This land was acquired for the construction of national highway. Several representations have been for this video before the authority, my lord. But already land has been acquired. But
compensation not paid.
no, I have not received any compensation.
Who appears for the respondent? MSR Bora.
Actually, Lordship, in this case, they have not made a party the NHIDCL. It is under NHIDCL. They have to make party, Lordship. That's 3C.
You are representing which department?
Lordship, I am appearing for NHI also, but 3C notification was issued by the NHIDCL. 3A, Lordship.
No, first find out whether the amount has been released, not released, deposited. If required, we'll carry them as party.
Lordship.
Let the respondent obtain their stated to have been required. Arbora, I feel.
1 and 2, Lord.
Yeah, proper. B.
এটা ভুলকে পাঠিয়ে দিয়েছে। একটু কথা কয়া।
4 and 6.
4 and 6. Who's for 5? Who's for 5?
5 seems
Five.
to be wrongly.
Additional Deputy Commissioner, National Highway Authority, that is not there.
I don't know. Who appears for 5.
Huh?
Addition to 7.
But he is the competent Kala, not National Highway
Be
Authority.
obtained by the respondent.
All right.
Particularly the National Highway Authority has written the scheme for them. Paid the petitioner. And if so.
খবর দেখ কালাই হবো।
With the reasons therefore. Let the instructors be placed for the board on 24th of July. And for facilitating the respondent with the extra copies be furnished within a period of 1 week.
Problem.
Please, Your Lordship. Here the petitioner is the is the owner of the proprietorship farm as well as the truck, Lordship, which has been seized by Sansari Police Station, Lordship, on 10/2/2020.
Third. Respondent one.
All Lordship.
Five. With the respondent complete their right. Except by petitioner being serving from office of the company. listed. So rely on a date.
All right.
Right. It is regarding accusation, my lord. The husband of the petitioner died in a motor accident, my lord. And the similarly situated matter already it was a by your lordship, my lord. WBC 6821 2023, my lord, on 14/6/2024, my lord. My lord, the representation at this 24, my lord.
Yes,
Notice should go. Lord.
you examine and pass order. Examine, pass order.
Look.
Third current councils. Yes.
My lord, dispose of. Oblige.
Please, your lordship. Lordship, this matter pertains to cancellation of GST registration, lordship. A notice was, auto-generated notice was, show cause notice was uploaded in a portal which doesn't open till date. And thereafter, they had passed the order of cancellation in the, in 17/7/21 during the period of lockdown, lordship. That was during the pandemic period. I did not come to know about this cancellation till I raised bills. And then when I came to know, I have filed the appeal, which was also, which was not allowed, lordship. Lordship will find the appeal at page, annexure 6, page 53, lordship. There I have written the reason why I was unable to file my returns and what has happened, lordship. Lordship may kindly come to page 53.
53.
Yes, your lordship.
Yeah.
Annexure 6, lordship. Lordship will kindly come to this point number 8, lordship. Point number 8, after that, category of the case under dispute, lordship, there I have stated, due to my consultant inability and lack of responsibility, all my returns were not filed on time, and in spite of payment of all the dues to the tax consultant, lordship, what happened is, I have made my payments, those slips also to the consultant, I have attached to my petition. Somehow he did not file the return, and only for non-filing of returns for continuous 6 months, my registration was cancelled, lordship. That's it. Therefore, and because the appeal had to be filed in 30 days and it could not be filed within that period, lordship, they have disallowed my appeal, lordship. So that's why we are before your lordship for.
What do you say, Mr. Gogoi?
My lord, on the last occasion, we had direct to have instruction whether this show cause notice was actually been served or not, or whether it has been uploaded or not, because they made a statement in para 8 of the petition that, my lord, they have not been served with the show cause notice. In this regard, my lord, I'd like to bring your lordship's notice to annexure 3, page 46.
Eight.
46.
It's
Annexure 3.
Yeah.
Lordship will see the number, my lord, from quote from below, my lord. It is dated, my lord, 29/6/2021.
Yeah.
My lord, the authorities have now downloaded the show cause. It is there in the very much there in the portal and has been my lord, submitted to me to place before the honorable court. It is already there, my lord. But they made a, my lord, false statement in the petition that, my lord, it is not there. Till today, my lord, they could not find it.
No, lordship.
May I read the para, my lord? Para 8, my lord, page 10. The petitioner most respectfully begs to state that the petitioner was also unaware that due to non-filing of return, the portal had automatically generated a show cause notice, which was, however, never served on the petitioner nor uploaded on the portal till date. Therefore, the petitioner never received the same till date and did not know of the existence of the same. It is there, my lord, very much. The deputy commissioner of taxes, my lord, he has downloaded it and has furnished the same to me to place it before his honorable court. But this plea that, my lord, opportunity was not given to them. And lordship will see the ground in the appeal. Yes, my lord, shifted the burden on his consultant. It says that due to my consultant inability and lack of responsibility. So, my lord,
my lord, they are proceeding in this particular case in a very casual manner. That's why they could not file it, my lord. It's not the fault of the authorities. And we are bound by the statute.
Now what is to be done?
That part, my lord, lordship will have to, my lord, examine, my lord. Now what is to be
Is
done?
there to examine?
Because the
They should
appeal
examine.
is time barred. Now whether, because it will be again, my lord, on the authority
They
to
can
take a
pay,
call.
make a assessment of the taxes, but pay. If they pay, your responsibility is paid.
One thing, my lord, if the order is passed, I will have to see instruction on that one, because there will be a floodgate again, my lord.
Why do you come with your instructions?
No, I have, my lord, specific instruction I have got, my lord. That was a query raised, my lord.
That's
And lordship will see this is the issue of 2021. Now we are in 24.
That's all right. You want to know that failure for cancellation of registration, what is the status? They will not be able to carry on their business.
They will have to go, no, they can, my lord. They will have to, my lord, apply for fresh registration. They can, my lord. There is no bar to that. They don't do that.
My lord, may I make a submission?
Yes.
If we if we take a new GSTN, the work which we have done, that revenue also will not go to the government, lordship. In the last 2-3 months, I have done some work and the bills are pending.
You are not worried about the revenue going to the government.
Now suddenly they are so worried.
You are worried about your benefit.
My benefit as well as government's benefit, lordship's observation is my lordship's observation is my submission, lordship, in this.
You are concerned about your benefit, not about the revenue going to the government.
But I am telling they will also not get anything. It will not serve their purpose also if my business is stopped. That's my only livelihood, lordship. Lordship's observation is my submission, lordship.
Case number to comment. Case number to comment.
2023. 5, 2023. Lordship, page number 5, lordship.
You go through this.
Yes.
Go and find out.
Well,
if there's anything
Lordship at 2, lordship, his bills
no,
will.
let it be day after tomorrow in the
not day after, next week,
next Monday.
Monday. This matter be listed on Monday and it may be planning council finance, so make instructions. You go through these 2 orders.
Lots of.
Matter.
Okay. You take a copy from.
Yes, ma'am. All right.
Yes. Okay. That would be nice. Yeah.
Regarding, my lord, the construction of the flyover at Mission Charity, with the new petition, my lord. The, my lord, may.
In respect of the plot which you now say is under.
Yes.
This is with that bunch of cases.
Yes, my lord.
Yes, those bunch of cases, my lord, are listed today from item 46 onwards. In my lord, item 47, lord, people recollect few days back, my lord, these matters came up before this honorable court. They had filed an interlocutory application, thereby seeking to, my lord, amend the writ application. And this honorable court, prima facie was of the view, my lord.
Take it up with 46, then, this item.
Yes.
Along with item 46.
Yes, because now they have, my lord, finally find a fresh writ petition. So perhaps that I will not be maintainable.
We take it up along
Yes,
with 46.
my lord.
The petitioner herein made an agreement for purchase of a quota of land, and thereafter by registered sale deed, petitioner has purchased the land. Lordship will find the registered sale deed at page 39. Page 39 is a registered sale deed executed by Nibha Borua, Lordship. Page 40. Start. Okay, got it.
39.
Page 39 is start. Page 40 is the relevant portion. Petitioner vendor is Nibha Borua. Lordship, got it.
Yes.
Before that, petitioner has verified the land record, page 33.
Page 33 is the relevant entry order sheet. Case is presented, peruse the case record, notice issued as per rule process server. No objection can be seen within the limitation period. In the report of the land months in the order. As per report, land month appellant in position. As such, considering the aspect of the Nibha Borua, wife of Viraj Borua is mutated in the place of record of Patadar Sri Devi Prasad Borua. And purchaser research number Iman. So my vendor name has been recorded in the revenue record. I have also verified the revenue paying receipt, page 36. Page 36, the revenue paying receipt. Hereafter, Lordship, the private respondent has tried to encroach the land and file an FIR before the officer in charge of Gitanagar police station. Lordship will find at page 46. Page 46. Is a handwritten copy. I have the honor to state that I am a resident of Birman. I have a plot of land at Hatigam measuring Imaniman, Hatigor, Charili, have Nami Imaniman, standing on the. From yesterday morning, evening, we came to know that some miscreants broken the lock of my land and started cutting the trees. I request you to take the necessary. This is the affair filed by one Kumuti Kumar Chaudhuri Lodge. Roy Chaudhuri. Lordship, thereafter, we have also filed an affair at page 47. Before the officer in charge regarding disturbance of position. Hereafter, Lordship, finding no alternative, we have filed a suit. Page 49. Lordship will find this suit at page 49. Lordship, page 49.
Yes.
Lordship, this court has session judge, civil judge, senior division session judge has passed an status quo order, page 67. Page 67 is the relevant portion. This is the my suit. Wait, Honorable Court has passed an injunction order. Page 11 portion will find at page 75. Page 75, Lordship will find. Dated 26 to 2023. Page 75. Lordship got it. Therefore, in the light of the appropriate discussion, this court is constrained to opine that passing of order of status quo will meet the justice. Accordingly, an order of status quo is passed directing both the parties to maintain status quo over the land till disposal of the title suit number Iman. Hereafter, Lordship, they have also filed a counterclaim in my suit, and another status quo order has been passed, page 76. Lordship will find page 76. There is 26 2023 relevant portion. Lordship will find page 85. Page 85 relevant portion. Therefore, in the light of the appropriate discussion, court is constrained to opine the passing of the status quo order will meet the justice. Accordingly, order of status quo is passed directing both the parties to maintain status quo. So both the parties were directed to maintain status quo by order dated 26 2023 by Civil Justice Senior Division, that is Kamrup. Lordship, hereafter, one application has been filed before the Revenue Authority for cancelling the mutation of order by vendor. After knowing the facts, I have immediately filed an application, page 86, to the circle officer. Lordship will find page 86. An application not to proceed with the correction of a plot of land measuring 2 kotha, tag number Iman. And we have stated that title suit number Iman is pending before the Honorable Court, and there is a status quo order. But the learned trial court circle officer, Lordship will find page 94. 96 is the original copy. Final portion, Lordship will find 97. Page 97. গীতানগর পিএস অনুমোদনৰ বিষয়ে ইমান তাৰিখে লিখিত প্ৰতিবেদনযোগে কামৰূপ মহানগৰ জিলাৰ মহামান্য ন্যায়িক আদালতৰ প্ৰথম শ্ৰেণীৰ আদালতত জনায় যে এই দলিলখন ভুৱা দলিল ৰেজিষ্টাৰ্ড দলিল অফ মাই ভেণ্ডৰ। সেয়ে সকলো পৰ্যালোচনা কৰি গীতানগৰ অনুসন্ধানকাৰী বিষয়াৰ প্ৰতিবেদন আৰু তাৰিখৰ মূল দুৱা দলিল সংগতি ৰাখি বাতৰি কাগজ নাকচ কৰি মাই ভেণ্ডৰ's mutation has been cancelled and Mondal has been directed to correct the record. So my submission to be Lordship, when civil court is executing the matter and there is a status quo order, Revenue Authority has no power. And this Honorable Court has already held that when civil court is pending, the civil suit is pending, the court of revenue court has no power to pass any order. Lordship, I'll place the order.
There is a provision in the revenue regulation also.
Regulations. Civil court is pending, civil court is executing matter. At this time, he cannot, Lordship. And there is a Supreme Court judgment also to that effect. And he has exercised jurisdiction in correction of the record without deciding the matter. That is civil court.
Yes.
There was stamp is fake law. That is, that is stamp on what bill still it was executed law. So that was fake law. What is it? Who law?
Civil court will decide what is fake
law. In police case is also registered law.
Heard. I have to appear for respondent four.
Four.
Five. Dated 6/6. That's no. It's directing the weakness. The land report. Inspector claims to have notified by the regulation in view of the fact that the deed of sale has been found to be and it has amended the deed of agreement and goes to the submit that he had purchased this land by executing sale and pursuant thereto his name is reflected while the matter was last way there was an attempt to encroach land by the private response because of which title suit was filed by the Court of Civil Jurisdiction by execution. Two 2006. Directed Court Party Statement. The private response number 5. Also five. Completely on which similar status quo directly. During the pendency of this particular suit, on the basis of complaints filed by the investigation, alleged investigation, and the circle officer on subject directly submitted by the during the pendency of the suit. Before a complainant or proceed for due correction. That the liberty thereafter and I have steps considering the submissions made by the learned counsel that the orders are which clearly reflect that there is not part of idea of the data. Directly for parties maintain status over the land over the suit land. The direction of the federal officer, the utmost of making necessary correction, the revenue report will have the effect of changing the nature of the land. May have the effect of changing the nature of the land. It may ultimately render which will cause difficulty in the disposal of suits presently pending. Injunction orders have been passed. Accordingly, with the matter being texted again, 2nd of August, till the next available date, the order date will pass by the system. Shall remain to be.
By order dated 9/4/24, directed to obtain the instruction from the PC.
A report was sought for your lord.
Orders come.
Lordship, this is regarding lordship, cancellation of bail lordship. A report was called for lordship. We have received the report lordship. And here in this report lordship, regarding the last allegation that pelting of stones to his house lordship, that regarding that part lordship, report says lordship that lordship, may I please this one? One small point.
Read it out.
That's on 29/4/23. The complainant was lost in an affair at Gavarupothar OP regarding pelting of stones by the alleged accused persons, namely Debraj Buragoy and his associates. In this regard, an inquiry has been made by Gavarupothar PSK OPGD number 623 dated 30/4/23, and SI Kumud Das was entrusted for inquiry. During inquiry, the EO did not find any evidence regarding involvement of accused Debraj Buragoy in the pelting of stones at the house of complainant, nor any person has been seen about their presence at the place of occurrence. Hence, no action has been taken against the accused person.
Lordship, the thing is that Lordship, the applicant filed an FIR Lordship against the opposite number 1 Debraj Buragoy Lordship. The case was listed under 323/307 Lordship. Now bail was granted Lordship to him perusing the case day Lordship. Now Lordship will find if the medical report Lordship, he was grievously injured Lordship, and he was 22 days in hospitalized Lordship. I have annexed the medical documents, page 23 Lordship. Kindly for a moment, kindly see Lordship, page 23.
What is the legal status now?
Now Lordship, he's okay Lordship. But the condition how he was.
That is a different issue, but how you are the record has violated any of the conditions. Has he violated any of the conditions? The report says.
Lordship, the report is made by the same IO Lordship. He did not take, even if the Lordship.
Why take steps against him?
Lordship.
We have no reason disputing the report of the IO.
The weapon which was used. Yes, Lordship. That for that reason, I have Lordship filed a subsequent affair and also submitted an application to the police commissioner against this action Lordship. But same authority have inquired and they said nothing found Lordship. I don't have any option. So, this is my case Lordship. That's why I came for cancellation of this bail. How he has granted bail.
May I submit, my lord? Whatever, my lord. After this, my lord, the case progressed, my lord. Now case has been committed. He is on regular bail. Case has been committed to the court of session. Trial is going on, my lord. Now their prayer is in practice, my lord.
But
because they have come for cancellation of the anticipatory bail. He is now on regular bail. And regular bail, the case has already been committed to the court of session. The trial is going on in full swing, my lord. Now they ought to have come for cancellation of if any grievances, and they could have edited these in the trial, my lord.
Where is the order of bail?
Yes, Lordship. Yes, 33, Lordship.
That is bail was granted 19/4/23, Lordship, case 33. Case 34, Lordship, observation, last part. Now, this report which was submitted by the IO, that is Lordship doubtful, Lordship. On the basis of the case diary, bail was granted. But medical report says that he is seriously injured, Lordship. That against that we have approached for cancellation of the bail on subsequent action of the opposite party number one, Lordship.
No, that may not be a ground, Lordship, that the report is doubtful, Lordship, that is why the bail may be cancelled, that may not be a ground, Lordship. One more thing, Lordship, that the second complaint, Lordship, they have lost, Lordship. In that complaint, they have stated, Lordship, that regarding that earlier case, PS case number, WR PS case number 94, regarding that part, Lordship, they have mentioned. So, Lordship, it is the duty of the officer, Lordship, to inquire into the matter, Lordship. And when they have not found anything, Lordship, they did not register the case, Lordship.
Obviously, there will be nothing.
Because
The
if
same-
they do not disclose that part, Lordship, regarding that case, Lordship, and then
the
say
same
part
IO,
case
Lordship,
maybe
same IO has submitted the charge.
maybe, Lordship,
But
maybe,
you
Lordship.
have to then take, you have to arrange the party.
That's true, Lordship. I admit it. That's true, Lordship.
Whatever the
And the case is now progress, Lordship.
But
Yes. You are praying for cancellation of
Yes,
your
yes, Lordship.
bail at page 33.
Yes, Lordship.
Order dated 94. Order the petitioner paid the following conditions. There are particularly grant of bail. It's present IA cancellation. Hearing and support their states medical to submit that because of the suffered can go out of the state for further medical care where the other methods are in para 10 IA, there is a categorical amendment that the case died which conveys the medical report, not reflect the actual statement. And that concern IO insisted that it is also taken I that proceeding date of the party on 29/04/2020 and about 30 midnight, 2:30 morning has thrown stone the house of the applicant after flying for principal member. There are also threatened the applicant not to withdraw the case pending. Upon such threats being made, the applicant he had approached the director general produced the mother of the applicant approached the director general made it by intimating the necessary change that the apprehension further allegations are made with the opposite party that the person involved in several legal activities, several FIRs against the applicant. Therefore, the order dated with the granting submitted date. Several respondents Reports. Take of steps taken by the agent of the apprehension based investigation. Idea was directed to call for the reports called for from the IO. The report reflects that on the basis of on the allegations made, investigations were conducted, but what was not found?
Lordship did not find any evidence regarding involvement of
But no evidence was found regarding the involvement of the opposite party. Is number one.
accused person, Debras Burgoyne.
Opposite party is also an active holding the claim of the applicant. And counsel represents the opposite party. Represent the committed sessions court.
Now second court, my lord. When we have filed it, now it is committed to the second court.
That is what stage is it?
Well, it is the committal has been done. It is now possibly on the evidence stage.
It's committed to the sessions. Trial is presented. Petitioner is appearing. The opposite party is appearing for the committed court on each day. And so the murders of that there is no allegation that I did anything on which the investigation from the report based to the court. You give us a copy. Read it. Keep by see. Clearly. I hope it's clear.
There is no any covering letter. That report is
Report begins from which page?
the earlier page, previous page. This is the last part.
Report forwarded to the SP.
Our page to let it know.
The report reflects that the report reflects steps taken by the IO pursuant to the complaint received. So steps undertaken are expected as step 7.1. Taking into consideration sufficiently and also taking into consideration that the state instead the case of court project that the petitioner not cooperating, not appearing or as or has violated any of the paid already. So the prayer for has been paid by way of IA at this stage. No later perusal notice, only the that this is not the case which fall within any of the instances that which also can be made done. So past it, that you have to frame it to state IA for copy of the report received by IO is kept in the case.
May I please, your lordship? Lordship, in a similar matter, your lordship was pleased to issue notice, lordship, in review petition number 61.
We don't issue notice because in a similar
Lordship.
matter, you argue, you state your case, why you want to review?
Lordship, there was a meeting held in the JCC committee, your lordship. It was not taken into consideration.
What is that similar matter?
Lordship, review petition 61, 2024, lordship.
You have a copy of that order.
Lordship, I mailed it, lordship.
All right, we'll take it up after a while.
Obliged, lordship.
May I please, your lordship? My lord, the order is already complied. The matter may be closed.
Order dated so fast. In
97.
Past it, the PPT were 8, 9. Taking into consideration the submission to the bar. Those the two.
Congrats, ma'am.
I'm paying for lordship 1 and 2, lordship.
The rest, so
1 and okay.
The counter affidavit was filed by the learned advocate of the government after last year. And I've also filed my return. What has emerged is that they have now and said that they are agreeable to do and they want to do a hydrological study, geohydrological study under the aegis of IIT Guwahati to ensure that the perennial underground streams remain intact. Now, there are 2 or 3 because certain directions may be called for from your lordships in this regard, because so far, because it is a good thing that the government has taken this step. I mean, it is appreciable, but the only factor is that so far the manner in which the project has progressed, there is a stark variation in the approach till now and then what they have said. So, may I just take your lordships to page 260 of the affidavit, 250, 260, running page.
of the affidavit of the state.
Yes, 260. Right. Internal page 8. Internal page 8, page 260. Right.
There are 2 affidavits, right? 1 affidavit.
Or by the state, one?
No, in reply, I have 2 copies.
We have filed 1 affidavit, they have filed 2 affidavits.
Oh, no, I think on the last day,
the 2 copies placed in.
No, the learned AG had handed over a copy last time.
No, we filed.
No, but we.
That we have taken back.
Ma'am, your lordship,
Page number?
internal page 8, 260.
260.
Page.
Filed by Raj Chakraborty.
Yes. 260, lordship.
Yeah.
So, my lord, somewhere below the second half, if your lordship will somewhere it is to ensure clarify in the second paragraph. Just it is to ensure clarify your lordship. Somewhere in the middle it comes. It is to ensure clarify that for your lordship. Yes. It is to ensure clarify that for carrying out construction of the proposed corridor, There will not be any damage or demolition or any cause or any destruction to the age-old structure of the revered temple of Ma Kamakhya and other temples in the vicinity. There will not be any damage to the sacred natural water springs due to the construction of Ma Kamakhya temple access corridor. In this regard, technical support is being taken from IIT Guwahati for hydrological and geophysical study, so there will not be any threat or damage to the existing perennial streams. All precautionary measures, including shallow construction, surface construction, will be taken during the execution of the work as per suggestion and approval of IIT Guwahati in this regard. So, Milad, in this regard, so they have started the process of consultation. Now, Milad, there are two aspects your lordships need to know: that they are consulting with IIT Guwahati and that no shallow construction will take place. So far as the tender bids, etc., have happened, they have progressed otherwise. That is what I wanted to bring to your lordship, because it should not be a post facto thing, because then we are in difficulty. If we are dry up, then it's irreversible. Your lordship, let's come to the bid document at page 103, 103 and 112. Because so far the trust, and this is the technical consultancy bid, page 103. For architecture, employment of architects, for engagement of architects. Your lordship, with this page 103, that's a press note of 18th of August. In the middle, it says consultancy services for Ma Kamakhya temple access corridor at Guwahati, rupees 386.75 crores, rupees approximate consultancy fees 13.46. Your lordship, may come to page 112. This is of 18th of August 2020. And now, your lordship, is background and aim of the project, the second paragraph there. During restoration, and upgradation of facilities around temple, it should be ensured that the beauty of the temple is preserved. No tampering should be done with the architecture of the temple. The corridor should be constructed by keeping the ancient sculptures undisturbed. So, the trust is on that there being only idols and structures, and they should be undisturbed. There is no mention anywhere about the underground springs. Now, Now, your lordship, may come to page 192, which is the bid consultancy. This is the construction. Go for the construction bid, at 192, it's at 192, that's of 28th of November 2023. At page 200, is the details of page 199, 200. 199 is the brief particulars of work for the construction tender. And at page 200, your lordship will see.
Development of site.
Yes, I have shown that to your lordships earlier also, where they say that there will be retention walls, excavation digging. There is no mention of underground perennial stream remaining undisturbed. Now, Milad, I will now take your lordships to the soil testing report, which is part of the technical. At page 335, I filed it along with my joint development. Page 335. And this is the ultimate page at 335 is the consultation. This is, we downloaded that from the Millad's website, 335. And it's at
335.
Yeah. I'm sorry, 335. Yeah.
Not 335.
335. 335. Soil project report, subsoil investigation, in the rejoinder.
This is a part of the rejoinder.
Please, ma'am.
Rejoinder.
Please, ma'am. Because the bid document was not filed in entirety. We've taken this part. This is downloaded from the net as part of the.
Yeah.
This is the project report on subsoil investigation. So, lots to have. Page 35. Your lordship comes to page 357. Last recommendation. I will, you'll have to. 357, chapter 6. A recommendation of foundation. From a careful study of test results obtained from both field investigation and laboratory analysis, as described in the previous chapters, the following conclusions can be made for better repair. As per the site data and analysis, above analysis is observed the parking field site of Ma Kamakhya temple complex is consists of filled up soil to maximum 4.50 meter depth. Hence, it will not be wise to rest shallow foundation for any structure on this variable loose filled up soil strata. From the above analysis, for higher loaded structures, we can adopt RCC General 5 as described in table 17 with 500 millimeter diameter and a length of 800 meters or up to refusal railway stake load up to 370 so and so. So, if your lordship will recall, I had showed from the affidavit that 2 points. One is that it will not be a shallow foundation. It will be a shallow foundation, they had mentioned, and this is not a shallow. Now, the implication of this, as I understand, was to the civil engineer, that 2 feet of pipe will be put in, and then they will go up to 8 meters, which is about 25 feet. In the process, what happens to the subsurface rocks, etc., is not known. So this is the implication of soil testing. So this is as part of the tender bid also. Now, my lord, if your lordship will come to another very important part, my rejoinder only, page 305.
Page
305. 305. The Pollution Control Board has given a consent to establish. Where page 305 minutes. Pollution Control Board has given a consent to establish. And this is a in the rejoinder itself.
In the rejoinder?
Yes. Part of the
305.
305.
Your rejoinder begins from 311.
Oh, I'm sorry. Is that affidavit in operation? I'm sorry. It is their document. I'm sorry. This is the consent to establish. This is actually the date is illegible, but it's 16th of March, 2024. This is a Pollution Control Board, Assam. To the top right is the date is the 16th of March 24. The end it is signed. Name of the work, Ma Kamakya Temple Complex. Name of the applicant and designation, executive engineer and of so and so. Address of the type, Ma Kamakya. Type of work, building and construction project. Cost of project is 334. That was original. Now your lordship may turn over the page. At page 306. Water aspects. Where is the water from the project going to come from? Details of your lordship water aspects at capital B, second part.
Yes.
Details of proposed source of water, sources of water, water consumption, effluent generation, and stuff. Source of water, your lordship will know groundwater. Water consumption, 430 KLD, means 430,000 kiloliters per day of groundwater is going to be extracted for the project. So today, my lord, if we are going to extract from the well, we are extracting groundwater, there is going to be subsidence. The water from the top is going to percolate downwards. So that's the view. In fact, I was put in a conference also with a former member of the Central Groundwater Authority that this is a serious implication.
What is CGWA?
Central Groundwater Authority. This is subject to permission, but the very proposal itself, the very fact that they are planning to do it, if CGWA clears, and because today, currently, Kamakya water is from municipality. Your lordship will come to my rejoinder of 352 I have shown. I have downloaded from the government website. Kamakya, there are 354 my rejoinder. No, 332, I'm sorry. 330. My learned friends, I stand corrected. 330. 332. This is from the Government of Assam website. Guwahati Municipal Corporation, Guwahati Development. Waterworks wing of Guwahati Municipal Corporation caters the need of the water in the city area. Guwahati Municipal Corporation has 3 water supply treatment plants at Panwazar, Satpuri, and Kamakya. Water is pumped from River Brahmaputra to these plants, and after processing in the plant, water is pumped to different reservoirs located at hilltops and then distributed to consumers by gravity means. Some areas are supplied to direct pumping also. So, if your lordship sees besides the plant, there are 9 deep tube wells at different locations. Installed capacity and present running capacity of each plant are dictated below. Kamakya is 4.5 million liters per day, I think, in 1992. Your lordship sees after Panwazar, Satpuri, and then Kamakya. So, today, even for Kamakya's own internal water, that is not groundwater. This is supplied to the GMC pumped up from the Brahmaputra River. Now, And then your lordships may, I'll show one more document at page 358. What has happened in cases like this, 358, because what is to be done? Because today, my lords, I mean, the state has indicated it wants to do a hydrological study, but what is the scope of the study? How has it been done so far? The seminal study 358, my lords, is a book actually. We've got the book, but I just filed the introduction. It is a report, it was a collaboration between the Geological Survey of India and the Archaeological Survey of India for preservation of the Ajanta-Ellora caves. Your lordship will recall on the last date I showed your lordship the reading a note from the Ajanta-Ellora cave, which is in the additional act. Here, my lords, the GSI was commissioned to do a survey, and my lords, there was a memorandum of understanding which is mentioned at page 364. This is the introduction to the report. At page 664, they mention an MOU, which was entered into between the thing. And at page 365 is the objective of the collaboration. I will read, my lords, your lordship will not bother. To understand the main objectives of the studies are 365. So, something similar we need to do, because today this is a project of seminal importance. If for some reason the water goes, then we are finished. The main objectives of the studies are main objectives of the study are to understand, your lordship has 365.
365, yeah.
The main objectives of the studies are to understand the nature, source, and extent of seepage in the cave, to detect and delineate the seepage conduits and channels in the rock mass above and adjacent to the cave, suggest remedial measures to arrest or minimize such seepage and protect the caves and its paintings and sculptures from further degradation, to assess the existing stability of caves in terms of various geotechnical parameters and likely impact of the artificial vibrations, to understand the effect of various elements of physical environment. So essentially, my lords, as I have already said in my earlier affidavit, and your lordship may come to the last 3 pages here of the next 366, 367, 368. These are, my lords, of the road. There's your lordship will recall there's a Pandu to Kamakya road which was built. If your lordship sees at page 366, the steep gradient this by PWD only has led to various accidents, and which is more evident at page 368. And in fact, while sitting in court only, I happened to search on the net, and it was quoted by the PWD engineer. 368, your lordship, the steep gradient is more than 40. They have said that they are now consulting IIT Guwahati, taking expert advice from them because the road is now closed for the public. So now they have consulted IIT Guwahati and for how to now redo this road. So today, my lords, we are today at a place because today the entire project has proceeded on the basis of excluding. The technical bid consultancy only says we are going to have the sculptures have to be connected. This is not a sculpture. This is the underground streams are themselves taken. The construction bid says we'll have retention walls, we'll have excavation, we'll have digging. Soil testing proceeds on shallow foundation. Now that the government has said so an affidavit, so we therefore need, and I think this is where, because my main concern, though there's an archaeological aspect, but today being a war pujari in the temple, my main and only primary concern is the fact that this aspect should be gone into detail, the entire hydrological aspect should be studied, only thereafter should it be proceeded with. And thereafter, my respectful submission to your lordship that the Solicitor General is also here, and they can get hold of the IIT Guwahati or the Geological Survey of India. Set out a scope of study of what has to be done. That is the primary important. Because today, if any work, typically in this kind of a situation, the hydrological study should have been carried out first and everything else designed around. It cannot be a post facto. Now that you are constructing another, once it goes, the water goes, then everything else goes. And my lords, in this regard, the additional affidavit I filed in the last state, my lords, which is, what is the, it's at page 248. Well, lordship, you just see 248, my additional affidavit last date. I had filed a report, my lords, of a former director of the National Institute of Hydrology, who had set out also the scope of study. 248, your lordship has. So at the bottom part, therefore, given the large-scale construction, including multi-level building, it would not only be appropriate but quite essential to conduct a comprehensive geohydrological study of the hill, so the springs supplying the water to the Garbhagriha area is not disturbed. The study needs to involve subsurface mapping using ground-penetrating radar around each temple with water in the sanctum or Garbhagriha. This will help to detect joints, fractures through which the water is flowing into the sanctum and also flowing out. Fractures, joints are possibly present all across the wheel, which is the reason why there are also water tank pools. Their source of water might also be through fracture joints, for which GPR survey around these pools is also necessary. And I had shown to your lordships also at just 2 pages away at photographs of the temple, Siddheshwar temple, where mother already due to construction around. And in fact, apparently the Dhumavati temple is also affected due to construction around. My learned friend had mentioned on the last day. That water inlet is coming in, as 250 on your lordship has seen. Water is coming in, but water has to be pumped out. So this is the pipes I have shown. This is one part, because without a comprehensive geological study, I would respectfully submit that it has to be done by two, because the consequences are two. Let it be done by one and then let it be vetted by the other. Because otherwise, we are, if it goes, there can be no post facto correction like the road. The road, if it is steep, apparently people are dying every other day in accidents. But this cannot be corrected, because once it goes, it goes. And I'm happy that the state government has come forward with this. It only now needs to be carried forward to its logical conclusion.
Yes, Mr.
I think there is a huge deviation from what exactly is the prayer in the writ petition, Lordship. Their whole prayer, although they have challenged the NIT of 15.3 and the work order thereafter, but their basic prayer is, Lordship, to declare Kamakhya temple as the ancient monument under Section 4 of the Ancient Monuments Act of 1958. This is their prayer. Fine. So their more trust is now on the tender as well as the work order. What is this tender all about? The tender is all about, Lordship, on three concepts: engineering, EPA. I am just coming, taking that your Lordship to that tender notice. What exactly is a tender notice? Lordship will kindly come to that. Page number said the repetition which has been given to us, there are mismatch of the phases. What is it? So Lordship will kindly come to page 192. So I'm going to the basics actually. Detail notice inviting bid at page 192. Here, in continuation of press notice dated 22nd November 2023, the Chief Engineer, PWD Building, Assam, invites online e-tender in two-bid system, eligibility and finance, on engineering, procurement and construction EPC mode basis. We have to understand what this concept is all about. Here, there are three stages of this tender process. First is the engineering, then the procurement, then the construction. There are three stages. We have floated a project. The concept has been finalized. What is this concept? To have a Kamakhya access corridor to Ma Kamakhya temple, so that there is ease in access to the temple by the pilgrims and all other stakeholders. So when this notice was issued, Lordship, we are looking for three areas where we want the consultancy and the work. The concept we have finalized. Next is engineering. During this stage, now we are at the engineering stage. What this L&T or the person who has been given the work, they have to work on the engineering part now. During this stage, they have to first design the drawings and various issues related thereto. What are the scope? They have to take the approval. They have to consult all the expert bodies in what way the design should be finalized. So their present stage is very clear. It is at the stage of engineering. So they are finalizing the working drawings. Once everything is done, thereafter, Lordship, the procurement stage will come and finally the construction. So the engineering stage involves all the expert bodies' participation. Nothing can progress until and unless the drawings are finalized. The concept is finalized. What is that concept? If Lordship wants to see that concept, I would like to give that document. In fact, we'd like to have a presentation before this honorable court, maybe in the chamber, in presence of the other side also, if required. This is the concept.
By chamber, we can have it.
No, it is, we don't have the access here. Because, let me go photograph, na?
That's all right. We'll do it.
Yeah, I'll go to that. Because there is a total attempt to mislead this honorable court. That's why I have to clarify everything. Yes. From this page onwards, the whole area we have to clear and we have to design. So that area which will be cleared, there are existing buildings there, existing commercial places as well as residential places. The whole area will be cleared. And if Lordship is look at the main colored photograph of the whole area, which the concept is all about, then it will give a direct access and visibility to the Ma Kamakhya temple along with the other temples. There are accused congestion now. This congestion has to be cleared. The facilities has to be established there, and thereafter the whole project will come into place. Now at this stage, the concept has been finalized, and the concept has been finalized not by the government of Assam. If Lordship is pleased to take my affidavit. Lordship will kindly come to page 285.
285.
285.
Your affidavit.
The affidavit in reply.
Your affidavit.
So now the present stage is of Lordship engineering, which includes Lordship finalization of the design, development and working drawings. That stage is now going on. Just like taking an example, I want to build a 3-story building. So I will tell my architect as well as my engineers to give a design. So they will go and verify the land, including soil testing and all other aspects, and they will design. That design can always fluctuate. So now we are at the stage of that engineering. So what we are doing now, we are giving the design development and working drawings finalization. That stage is going on. Once that is finalized, after getting all approvals, thereafter the procurement stage will come. That means the material procurement plus the labor procurement. And finally, the construction will start. That is the last stage. Now, page 285, the first meeting of the Government of India, Lordship, Ministry of Development of Northeastern Finance and Economic Affairs Wing on 5th October 2023. Minutes of the meeting of Empowered Inter-Ministerial Committee of Prime Minister's Development Initiative for Northeastern Region, PM Divine. So this is the first meeting. Then Lordship will now come to page 287. This is the third meeting. Minutes of the third Empowered Inter-Ministerial meeting held on PM Divine scheme on 26 September 2023 at 10:30 at Vigyan Bhavan. Here, the project for Assam is taken at 288. At 288, Assam is at down below. 1, 2, we can skip. 3 also, we can come to that number 3 at page 289. Development of Ma Kamakhya Access Corridor at Guwahati in the capital region, 499.89 crores. Stress the importance and visible impact of the project. The state government informed that many departments of the state are involved, and the state government assured that this can be accompanied after achieving necessary coordination and conversion. Recommended in principle. Assam on the right-hand side. Assam state was further advised to resubmit all the 3 DPRs of the recommended projects within the indicated normative allocation of the state. This is regarding the progress of finalizing the concept. Then thereafter, Lordship will come to page 290. And what I am trying to stress upon here, when this meeting takes place, now it is a fourth empowered meeting on 21st November. Which are the participants here? Lordship will also see all various departments, including at serial number 16, Secretary, Ministry of Culture, which is the parent department of the department which according to them have to be the important party in this case. So that party is called Director of Archaeology and Directorate of Archaeology, but they are indicating Assam, but I am also indicating Archaeological Survey of India, respondent number 3. So the respondent number 3 comes under Ministry of Culture. Now going ahead, fourth meeting, at serial number 1 at page 293. Last one, serial number 4. Development of Ma Kamakhya Access Corridor. The state government confirmed availability of land for the project and also stated that interagency coordination will be done by the state government. The state government to submit the copy of the award of the contract to the ministry to expedite the work. On the right-hand side top. And finally, at the right-hand side down below, recommended for approval. So this project was approved on 21st of November 2023. Then fifth meeting had taken place on 15th of December 2023, 294. That was further approval, and there's a continuous process going on. And finally, the another minutes Lordship will find at page 297, the relevant portion. This is the minutes of the 5th Empowered Interministerial Committee. At page 298, serial number 4 down below. It was informed regarding Kamakhya Access Corridor. It was informed about certain observations of the internal finance division which needs to be addressed by the state government before issuing of AFS. State governments to expeditiously submit information clarification to the ministry's observation. Then the 6th meeting, Lordship is also there. Here also the cultural department, all the other parties were present. And finally, at page 302, this is the 6th Empowered Committee's meeting held on 5th of January 2024. And Lordship will find the relevant portion at 304, serial number 4 again. Development of Ma Kamakhya, it was informed that AFS for the project has been issued on 4th January. State government to award the work expeditiously. So everything is being done in total coordination with all the line departments. Nobody is avoiding anybody, whether it is Archaeological Society of India or other departments under the government of Assam. Now this tender was issued in the EPC mode, and the EPC mode has 3 stages: engineering, procurement, and construction. The tender was issued, work was allotted, foundation stone was laid by Honorable Prime Minister on 24th of March 2024. Work has started. Which work? Which part of the work? The work is relating to the, because the concept was already approved by the central government that there should be a corridor. The corridor is in sync of, or it is more or less in the similar way, which is been done in Kashi Vishwanath Temple in Varanasi, as well as another temple at Mahabhairav in another place in south.
Mahakal.
Yes, my friend will know, because he has done a lot of research on this. But I am totally on the legal issues now. Now we are at the engineering stage. So we are now, the design development work is going on, as well as the working drawings are being prepared. For that purpose, my learned friend started the submission today that we have finally agreed for hydrological test. And he read few lines, but he did not read the final line, where we have stated that on 6th of April, we started this process of engaging IIT Guwahati. Not as an afterthought or as a knee-jerk reaction now because of this petition. There are a lot of agendas nowadays, Lordship, of this kind of petition. I do not know what are the vested interests involved. But the thing is that we know what we have to do. If there is any deviation, definitely Ma Kamakhya will not tolerate anything which is being done by the state of Assam or its people. So what we have stated in our affidavit, that we have started the process of engaging IIT Guwahati on 4th of April. And this writ petition, when it was filed, I think it was filed on 21st of May. So much later. So our first letter with IRC, first communication with IIT started on 4th of April. After on 24th of March, the Prime Minister inaugurated laid the foundation stone. Therefore, I would like to read out 2 paragraphs from my affidavit.
Yes.
Basically, in paragraph 3, Lordship, we have indicated what we have stated in the affidavit. We have filed in the PIL, the connecting PIL. Actually, the PIL is the main where identical issue has been raised and it is being adjudicated. So in paragraph 3, we have stated about the PIL affidavit filed by the Chief Secretary of the State of Assam. And now Lordship will kindly come to paragraph. In paragraph 3, we have referred to all the developments that had taken place at the central government's level of the various meetings, etc. Here at page 5, 257. And let me read this paragraph also. That will give the overall picture. Paragraph 3 onwards. The petitioner has failed to show violation of any fundamental or legal right of the petitioner, which is infringed by Ma Kamakhya Corridor project undertaken by the respondent. The deponent stated that Ma Kamakhya Access Corridor, in short, the project work, is to be implemented and it has been specifically decided during the restoration and upgradation of facilities around the temple. It should be ensured that the beauty of the temple is preserved and no tampering should be done with the architecture of the temple. The project work should be constructed by keeping the ancient scriptures undisturbed. Therefore, the projection sought to be made by the petitioner as regard disturbance to be caused by the project work in performing puja is absolutely misconceived, misconstrued, and baseless in nature, and therefore the instant petition is not maintainable. The deponent further stated a similar issue is pending before the Division Bench of Guwahati High Court in PIL number so and so, wherein the petitioner have alleged that Ma Kamakhya Corridor has caused huge amount of apprehension and created a serious situation among the devotees sadhus of Ma Kamakhya temple, as they apprehend that the project work would have serious and adverse impact on Ma Kamakhya temple and other temples, natural streams, etc. It is also alleged in the aforesaid PIL that the project work has been undertaken without any precautionary measures and without any intention to preserve the historically important ancient deities and the temples and monuments. In the aforesaid PIL, an affidavit has already been filed by the deponent on behalf of the state respondent, wherein it is categorically stated that the entire project work has been undertaken to develop the area without touching Ma Kamakhya temple and other temples in any form, be it infrastructurally, religiously, and preserving and protecting its glory and significance as it is. The apprehension raised by the petitioner are baseless and concocted in nature. The deponent further respectfully stated that as 5 meetings had been held in the Ministry of Development of Northeastern Region under Government of India relating to the activities of the empowered interministerial committee of PM Divine, in which the project in question, that is Ma Kamakhya Access Corridor, was mooted, discussed, and approved. So the concept was approved here. In this meeting, various interdepartmental and 9 departmental officials, including Department of Culture, were present, under which the archaeological survey comes. Further, while executing the project of Ma Kamakhya Access Corridor, any existing rules, norms shall not be violated. The deponent most respect humbly and sincerely undertakes before this honorable court that while executing the project work, statutory requirements shall be complied with and there shall be no tampering with the existing structures and monuments of Ma Kamakya temple. It is also stated that the decision have to be taken after discussion at various levels and no objections has been raised by any local resident. Only on the basis of hypothesis, the petitioner have shown concern as regard construction, demolition, etc. In fact, the bid document at Annexure K to the writ petition itself is very clear about the proposed constructions. It is reiterated that the petitioners has approached the Honorable Court by making some baseless allegations and apprehensions with an intention to stall the developmental activities for providing better pilgrim facilities and facilities to the peripheral area of Ma Kamakya Shrine. The only work which is being sought to be undertaken by the state is developmental work for providing ease to access to various devotees which come to offer their divine prayer in the temple complex, which at present is in existence in a very haphazard and chaotic manner. It is further submitted that there is no decision taken by the state at this stage to even attempt to alter any of the temple complexes. Prior to issuance of the NIT and the notice to proceed, a consultancy service was called for, and it is after in-depth study of the entire practice and ancient scriptures which are prevalent there, the state has decided to carefully chalk out the plan for carrying out the developmental activities under the central scheme called PM Divine. It is categorically stated that deponent that the project work will not impact in the manner of worship and overall sacredness and uniqueness of the holy deity, and the project work in question has been undertaken by the respondents without touching any of the temples in and around the temple premise. The developmental work is proposed to be conducted after due publicity and detailed meetings and conferences held with the representative of Bordeuri Commerce. He belongs to one of the member of this commerce and other government officials along with the state administration at the highest level. However, no such objection at the relevant point of time was raised. In that view of the matter, the intention of the present writ petitioner in filing the writ petition challenging the impugned orders does not appear to be bona fide. The deponent is the Kamakya is a periphery are not declared archaeological site. The project work has been undertaken by the respondent authority in the greater public interest, and therefore the personal interest of the petitioner without any semblance of right cannot prevail over the larger public interest, and the writ petition is therefore not maintainable. The affidavit we have annexed. Now coming to paragraph 6. We are basically reiterating before this honorable court also.
So essentially, what you are saying
May
is
I complete this?
that the IIT has already been, you have already been in parley with the IIT.
The final MOU has to be signed now because there are interactions between, I have all the documents.
What is the MOU about?
MOU, what are the areas they are going to look into?
Who? IIT.
IIT. Once they look after everything, and also my learned friend, what he was referring to this pollution control board's permission, consent to establish.
So when is the MOU likely to be signed?
The approval has already been granted. I have the draft copies of the MOU also.
We don't require, there is a categorical averment in page 259.
Yes.
That
we are going to sign because the interaction, there are communications.
IIT is going to undertake hydrological and geological.
Yes, that approval also has been granted. Let me give you.
So you proceed with this at the earliest.
No, Lordship. That thing is that regarding the approval of hydrological, because IIT did not mention that. IIT said that geotechnical studies. Geotechnical studies covers everything. Now we have given a specific approval also to that also. That's part. I'm just giving 1 second. State government.
State government is making a draft report this week.
Lordship may kindly have it. In affidavit will connect this also. But the draft also, it has been finalized because there were some suggestions. There were some suggestions from the IIT Guwahati also. With affidavit will file it. And whatever queries you are raising to RTI, we are giving all replies also. Will not hide anything.
Okay, we are going by your affirmation in the affidavit.
Absolutely, Lordship.
That,
No,
your
it is not that because of this repetition, all this development has taken place.
That's okay. That's not, it's not about who has thought about it. We will give you that.
No, the
that-
thing is like this, Lordship, now, because
the
in the
state.
newspaper, the different kind of story comes every day. That is the issue.
Newspapers will.
No, Your Lordship is not influenced, but the public represent, they are influenced by the newspaper reports. So it is not that all of a sudden, this huge project of 499 crores have sprung up.
Right. Now let us, that the chances, the apprehensions expressed are that unless you do a proper hydrological study, there could be a danger to these. internal
Now,
streams.
yes, Lord, for that, Lordship, may I just submit? When that study can be done? That study can be done once we remove all the present structures there, the construction, the household buildings.
That
These are
information-
technical things.
No, that recommendation has to come from the consultant.
It was already there, Lordship. It is not that all of a sudden we cannot do the hydrological test without removing the households because the home pipelines, water lines, that will also give a image, number one. And the water supply, which my learned friend was saying, that Kamaikhat,
Let the consultant state it or place it by way of some document to decide that this is the manner in which we propose to do it.
that we are giving, Lordship, it's a still process is going on. It's a continuous process. If Lordship wants the development with IIT Guwahati, there are series of communications from April till today.
Development, kindly come to your averments made in page 259 of the affidavit. The averment in the second paragraph is very clear that they will undertake hydrological and.
We are doing it, Lordship. We are doing it.
And clearer in the next page, page 8, bottom one.
These are our affidavit. We have clarified everything, and this way we have clarified before the division bench also.
No. So you are perhaps submitting that this study cannot be done without removing the structure.
No, parallelly all things are going on, but constructions cannot start now until and unless because this EPC mode tender, Lordship.
Very
It
well,
is
we understand. Now it is.
once
at the
whatever drawing will be finally given, the payment will be made according to the built up area.
engineering stage. It is at the engineering.
Initial stage.
Engineering stage.
Engineering stage.
So which is related to designing
The
and.
finalization of the design and working drawings.
But you have made a statement that you will carry, the IIT will carry out the hydrological study.
Absolutely, Lordship.
So, let the study be carried out.
Yes,
By
it is
IIT.
going on. It is going on, Lordship. The final regarding this is the approval of modified draft MOU. This is of 6th May. So IIT wanted some changes in the MOU. So draft MOU also have. We are inserting certain additional things. They are requesting certain more things. So there are interactions between IIT and the Public Works Department is going on. And I am sure, Lordship, with this approval of the Chief Minister and the PWD Minister, I think in 10-15 days or maybe in a 30 days time, the MOU will be signed. Those studies will be done. It is constructions cannot, because before construction, we have to have another stage, that is procurement. So therefore, in my humble submission, Lordship, there is no issue of granting any stay order, number one. Number two, Lordship, because they are harping on stay order. The work has to go on till we reach the construction. That stage is far ahead, far down the line. So at this stage, let us go ahead, and in the meantime, whether they want to pursue this petition or not, because parallel proceedings is going on the same subject matter. Either this case may be withdrawn or this may be tagged with the other case, or that case, I don't think that it's a PIL. So their main prayer is that Kamaikha temple has to be declared as a monument under the Act of 1957 and rules of 1959. Whether they want to pursue that, because that is a very serious prayer. If that prayer has to be accepted by this honorable court, then the first casualty will be the whole people who are involved with the Kamaikha temple. It will come under to the government of Assam, and the deputy commissioner will be the owner of that temple. There will be no pandas, nothing. So he himself will have to first vacate the place and give up his practice there.
One of which prayer is also the hydrological.
Yes,
study.
page 43 of the prayer.
And Lordship, we are giving Lordship. It is not that we are not doing.
And my lord,
And
for the archaeological-
I did not interrupt. Number one, and there are misrepresentations before it. From where the water supply is coming now to Ma Kamakya temple, GMC is supplying. What is that? I remember this honorable court engaged me as a advocate commissioner in 2008 or 2009. There was a litigation going on. The present Guwahati's water supply project, whole water reservoir is at the top of Kamakya Hill. The water is being pumped from the Brahmaputra river and it has been stored there. The whole water supply of Ma Kamakya temple, whole peripheral area is from that, and it is not only there. It is more than 50% of the Guwahati's water supply comes from that reservoir. So these things, basic homework should be done by the repetitioner.
Are you saying that the water which he says comes from the
No, what he is saying, what he is trying to say from that, this pollution control document, that construction, that the water which will be required for construction purpose, it will be drawn from groundwater. This is what we are not going to, at present also.
There is no construction.
No,
Not happening
no,
immediately.
there is a difference. The present households there, who is catering the water there? Whether it is groundwater catering or it is water from the GMC. It is water from the GMC. And GMC's water is drawn from Brahmaputra river, and that same reservoir is catering water to more than 50% of Guwahati's water supply. If suppose there is a construction tomorrow, water is already there. For that, you don't have to do underground pumping of water. So these are things which definitely, if we are not well aware of the factual situation, it will confuse everybody. So my humble submission is that Lordship would like to give an additional affidavit to their reply, because they have submitted another affidavit yesterday bringing this additional thing. So we'd like to give a press response to that by annexing not only the MOUs, plus various communications going on, including that document which I have just placed, as well as the supply of water in the existing system in Ma Kamakya temple's area.
Very well.
Look,
And I am still yet to argue. I am not placing all my cases because this submission we have made in Supreme Court in the month of November. And Supreme Court, there is a direction in our affidavit that you follow and commit whatever you have committed to the Honorable Supreme Court regarding development and this PM Divine's in full letter and spirit. May I place that order, Lordship? There is an order from the Supreme Court now. Lordship will kindly come.
No.
Yeah.
Page 300. Oh, this is in PL. In the affidavit, Lordship, which we have filed, Lordship will find that order. Just 1 second. Yes, 280, 279, it starts. I'd like to read 2 paragraphs from this Honorable Supreme Court's order.
So that's all right. But
At paragraph 4.
What we want to know is that you are now filing an affidavit.
Additional affidavit.
Additional affidavit. Very well, you file that affidavit, bring whatever else
Lordship.
to bring on record.
Lordship.
And meanwhile, also apprise the court what steps you have taken towards the hydrological study.
Yes.
And we'll record your submission that you are not proceeding with the construction as on date.
That observation, because it is not possible.
That's why. So the stage at which the
now present stage is engineering. That is my submission may be recorded in there. At present, the stage of engineering work is going on, which includes finalization of the working drawings. The next stage will be, Lordship, the stage of procurement, and the third stage will be construction, which is far ahead.
Yes, Mr. Hazarika.
That's the prayer, as your lordship rightly pointed out, that part, I have made that prayer regarding the water, the prayer J. Prayer J. Now, my lords, as far as the draft MOU is concerned, my learned friend is filing that. Now, my lords, today my learned friend is speaking on behalf of the Archaeological Survey of India. He's speaking on behalf of the IIT consultant. Now, these are, and today it's a PWD chief engineer who is testifying to all of this. We want, my lords, the consult, because today the matter is.
That's what he wants to bring on record
Very.
by way of the MOU.
Please.
Whatever MOU or whatever document, it will be on record.
And one of the PCBA, the approval I am reading from on the document, it says that the source of the water for construction will be groundwater. So if he says it is not groundwater, then
He has made, there is a categorical evidence that they are now proceeding for hydrological,
yes, at
geological. And the Advocate General has also submitted that is at the stage of engineer.
Please.
Therefore, it should be followed by procurement before the construction can start.
Yes.
So, under these circumstances, we record it and give them time to file
Right.
the additional affidavit or reply.
Yes.
And thereafter we decide
Yes.
if your prayers are allowed or.
No, my main concern, if I may say so, because they are today as a board pujari in the survey, it cannot be a case of operation successful, patient dead. That the whole project comes in and then the water source is still right. So, and this is what they have said. In fact, what you read in that paragraph 7.
No, we understand your apprehension.
Please.
So,
That's all.
and the readings we completed.
Yes,
because
yes, and the maintainability issue may be heard also.
We are keeping
That
it for-
that issue may be kept open still. I am still to argue on the point of maintainability.
This is at the admission stage, so you can always argue.
Yes.
Whether the report from the IIT may be called for also in the.
No,
They
how
are
can
yet to
IIT get
enter into
report?
an MOU. It's the MOU they want to bring it. Heard, Tariqa Lagat Singh Accountant, assisted by Mr. PR Talma. Yeah, sir. Mr. Also heard Mr. Like, Advocate General Singh Assam, assisted by Mr. T. Nam. Mr. R.K. Dev Chaudhary or Deputy Solicitor General, Mr. Bhattacharya or the private respondent number 10. Right. The petitioners have filed joined the affidavit. The affidavit in opposition. When did you file it? Today?
Yesterday, we served them. Yesterday.
Like yesterday. Copy has been called. Yes, record. The government in the affidavit. Statement. Submit that the department.
KG.
That department.
2601.
The Department of Public Works, Building and Highway has it's proceeding execute an MOU for scrutinizing the drawing relating to the construction of the Kamakya Temple corridor, and by scrutinizing the same, the IIT committee will undertake hydrological and geological study and it will take. So there is a clear requirement that no construction will start until new clearance from the IIT is received, as well as from other relevant agencies. Stop.
Lord, may I just interrupt? Even our NIT very clearly that only after obtaining all approvals from all competent agencies, then only the construction. In the NIT itself, it is written.
The Advocate General further submits referring to the NIT that the NIT itself, there is a clause which stipulates that clearance from all relevant agencies are required to obtain prior to taking up any construction. It reiterates its submission that there will be no damage to the temple
Existing.
sanctum, existing temple sanctum, or the internal screen within the temple as approved by the
Also this
competition.
the preaching practices.
That is NIT is the 94. NIT is the, what do you say, EPC mode.
EPC, Engineering,
EPC
Procurement
mode,
and Construction.
which is engineering procurement. So it submits that at this stage, the progress made is at the engineering stage, which means that the drawing and clearance, etc., are required to finalize. Design has to be conceived of, finalized. Only after that stage is over, the project will move to the next stage, procurement of relevant material, and thereafter, for due completion of the first stages, that is engineering and procurement, the construction will proceed. Therefore, at this stage, the apprehension expressed by the government that immediate construction is likely to be undertaken is not correct. Further submits that in view of the additional affidavit, reply affidavit filed by the respondent, filed by the petitioner, he would like to bring record certain relevant documents, including the MOU stated. You are bringing the MOU?
I'm not bringing the MOU. I will not say. The
Relevant
developments
documents,
relating to signing of the MOU.
relevant documents and other papers which may be necessary or which are necessary in support of the respondent by filing information affidavit. Submit that the respondent will submit 2 weeks time.
Lordship, let it be 4 weeks. And if the MOU is filed, signed, then we'll bring that also.
4 weeks will make it 6 weeks.
No, 4 weeks.
Because you are getting 2 weeks buffer anyway.
Yeah.
2 weeks or you make it
Yes.
like 3 weeks time.
3 weeks.
3 weeks time. Fine. Happen.
We expect within 15 days the MOU will be signed. You will bring it.
He further submit that the question of maintainability of the retention should be kept open as the primary prayer of the petitioner for really the Kamakya temple monument. What is that act? Ancient Monuments Act.
Ancient National Monuments and Historical Protection
Ancient monuments and historical.
and archaeological sites and remains act.
You want it to be brought under both the acts, central and the Assam.
Well, either of them.
In the prayer.
Yes, either of them, whichever. In fact, I think the competent authority to file a reply would be the Archaeological Survey, respondent number 3. Let the Union is here, the Deputy Solicitor General can file a reply there.
Or Assam. Assam ancient. Rapid by the learned company. With the manifestation again. First week of August.
Lord.
Well, it's too late. Let's say third week, reopening 1 week after that.
29.
Let it be 27.
24.
Very well. Whatever. Because I have kept myself for myself personally. This is overriding price.
24th will be a holiday, Lordship.
Is it?
July.
Sorry. I'm
It is,
sorry.
yeah.
Yes, 24th is fine.
And let the respondent number 3 file his reply, Archaeological Survey of India. So they are the ones who have to depose in this.
The Union should also file its response.
That's at this stage. So it's not declared as like.
But
You
why?
don't know whatever
It is a
you
prayer,
want
I
to say,
read.
you say,
Then you say
Those
why-
minutes speaks volume, Lordship.
Those minutes say nothing about it.
including the Archaeological Survey of India. You file if you want to file. It's permitted to file that reply. Let the matter be listed again on 24th of July. 24th of July. Further orders as may be required.
Please, your lordship. Lordship, I have found the order copy, lordship. Lordship, it is a similar matter where your lordship was pleased to issue notice, your lordship.
Okay. To notice. Is this matter, both the matters together? Yes.
Obliged, your lordship.
May it please, your lordship. Before my donation submits, your lordship, as per instruction of my client, I need to withdraw my wakalatnama, your lordship, on behalf of respondent number 3, your lordship.
To withdraw.
Lordship. I may be allowed to.
Mr. D. Bordoloi, counsel when entered in the 3. Submits that you have already withdrawn or you
No, your lordship. I'm seeking a permission.
submits that you'd like to withdraw the wakalat. Is recorded. The council may file necessary application before the registry.
No.
Praying for the registry will make necessary not of its own after the application.
No.
Yeah. Then
Lordship, steps have been taken on respondent number 2 twice.
you're for 2.
No, your lordship, I am for 1. And your lordship,
the
respondent number
recovery
2 is the DRT. It's not a necessary party, your lordship.
Recovery officer DRT is not supposed to.
Case may be proceeded with.
The recovery of this order is challenged here. And it is not maintainable because of section 30 of the RDB Act. your lordship.
If Lordship may recollect, Lordship, there was one borrower, one who is the petitioner, and one guarantor who is the respondent number 3. Both had given one properties in mortgage to the respondent number 1 bank. The borrower's property was auctioned by the bank. And leaving aside the mortgage property of respondent number 3, the bank proceeded with attachment of other non-mortgage property of the borrower. That is this petition. So it was tagged with another petition, item number 67 today, Lordship, because that has been preferred by the guarantor, which he had preferred before auction of the borrower's property. But now that the borrower's property stands auctioned, the mortgage property has to be realized. This is the crux of the matter, Lordship.
Yes.
Your lordship, it is not maintainable at all. Because any questions that has been arising from the recovery officer's order that has been decided in 2015 by the Honorable Supreme Court, your lordship. And any order, anything else relating to the DRT, it should be challenged before the DRT or the DRAT, your lordship. And in many of the matters, our division bench is also decided that this matter should not be entertained, your lordship. Because they can very well challenge. It is not that the DRT has no jurisdiction to entertain such kind of petitions, your lordship.
The Lordship has passed an order in an interim application on the last day, wherein they had filed for amendment because they had made a submission during motion that there are no other mortgage properties, all properties have been auctioned. Subsequently, they amended it by filing an interim application. Now, Lordship, it is not only in this court that they have made a false statement. In the DRT also, they are continuously making false statements. Lordship will peruse at page 90 of my petition.
Why don't you take recourse to the statutory remedy?
No, Lordship, if they would go to the statutory authorities and they would keep misrepresenting, there has to be some checks. The Lordship will peruse their illegality at page 90 of my petition, Lordship.
Yes.
If I may please read, Lordship, third paragraph. CHB, Certificate Holder Bank, filed report.
Page
page 90, Lordship, 90.
Yes.
Third paragraph, Lordship, CHB, Certificate Holder Bank, filed report that demand notice has been published in 2 newspapers on 12/4/22, but presently there is no any security available with this account. Hence, CDs may be directed to declare their property. So they will make false statements before DRT in spite of the mortgage property of the guarantor being available in the account. They misrepresent before the DRT as well as before this honorable court, Lordship. This is their first illegality, which I need to point out. Thereafter, Lordship, I had filed a petition before the honorable DRT, which is at page 100. So that might escape their notice, so I pointed it out. Paragraph 3, Lordship, page 100.
Yes.
That your humble certificate debtor number 1 further begs to submit that he is equally surprised to note that as mentioned in the certificate holder bank has filed a report that there is no any security available with this account, though the certificate holder bank has completed auction of the secured assets of certificate debtor number 1 without touching secured assets of the CD number 2 for reasons not known to CD number 1. The CD number 2 has filed WPC number 4961/18, wherein by order number dated 11/12/20, the Honorable Guwahati High Court granted liberty to certificate holder bank to attach the immovable property of CD number 2. Now, Lordship, before this court, when the guarantor had preferred the WPC, the interim protection was vacated by this Honorable Court. It was pointed out by me to the Honorable authorities of DRT. In spite of the same, they have not decided this petition. They have just kept it with the record and they have passed the impugned order, Lordship, which is at page 97. Certificate holder bank files report that shows one property details of CD number 1, that is in the name of CD number 1, prayed for attachment of other property in the name of CD number 1. Accordingly, it was directed to attach the said property without any discussion on why they have left aside the property of CD number 2 in spite of it being mortgaged and the property being attached by this order being non-mortgaged. And they have not decided my petition even. They have not even acknowledged it.
So therefore, there are appellate forums available. You go
Lordship.
and find your remedies before the appellate forum, statutory appellate forum.
No, but Lordship, there has to be some respect to the rule of law if they keep on ignoring the petitions without even deciding it. If they decide it, Lordship, maybe perhaps I have to go to the appellate forum. But
You can file applications before the appellate forum for that. Show us the provision.
Your Lordship, section 30, subsection 1,
Which act is
recovery of debts and bankruptcy. Lordship, it is very clear that any order passed by the section 30, subsection 1, Your Lordship.
30?
Yes, Your Lordship. Notwithstanding anything, it starts from the
notwithstanding anything contained in section 29.
Yes, Your Lord. Any person aggrieved by an order.
Appeal is against an order to
Yes,
be
sir.
passed by the recovery office.
Yes, sir.
And what order was passed by the recovery office?
to attach the other property of the CD number
Any
1,
other order?
page 97, Lord.
97, Your Lord. And basically, the writ petitioner is aggrieved by this order. And he is saying that we have concealed the fact.
There is a statutory provision here.
No, Lordship, there is a statutory provision, but High Court can always check if there is apparent illegality on record. I have shown to your Lordship that they have misrepresented before DRT that there is no security before the bank. If they are allowed to make such misrepresentations
This
without.
order was passed on 13/9.
Yes,
Yes, Lordship.
23.
Lordship.
So
Immediately
at this
thereafter, I approached this court,
no,
Lordship.
so today at this stage to decide on this issue when they're in the face of an alternative remedy would not be proper.
No, Lordship, the only direction that I seek from this honorable court is, since there is already a mortgage property in the account, which has been admitted by them, that may be realized first, and if it is necessary, other properties may be.
Your Lordship, I may.
You are aggrieved by this order, there is an appellate forum, go for it.
No, but they will not even entertain my petition, Lordship. I have pointed out by filing a petition, they have not even acknowledged my petition. And their apparent illegality has been mentioned in that petition.
So, but when did you receive this order?
13/9/2023, Lordship. It was passed. I have filed on 9th of November 2023, Lordship.
So within
1 month, your Lordship, after elapse of 1 month time.
you have to approach the court within.
I had obtained
within the
certified
appellate-
copies, Lordship.
Sorry?
I had to obtain certified copies. I
Whatever
obtained.
you have to do, you have to file it before the appropriate authority.
No, it has been filed within time, within appellate time, Lordship. It is not out of time. I will show to your Lordship. And moreover, since this court is already in session of the matter filed by the guarantor, Lordship, there will be simultaneous proceedings before two different forums. If I don't come here, the item number 67, which is listed today, Lordship, it is already pending here since 2018.
So we'll dispose of both the matters, you approach the appellate authority.
Lordship, with the direction to go against the mortgage property.
We are not
That
issuing
is the
any direct-
only relief which I seek from this.
We are closing this matter because you have an appellate authority, you have not proceeded. You know the rules, you know the parameters where it can be issued, notwithstanding alternative remedy.
Only with the direction to dispose of my petition, Lordship, which I have filed before them. They have not considered. Only
You
that
have-
direction will
You have
suffice.
filed an appeal against this order.
No, I have approached this court, Lordship,
Then
but I have filed a petition before the original authorities, which they have not considered. So even if a direction is given to them, Lordship, page 100. Page 100 is that petition, which has been filed before the recovery officer. He has not even acknowledged it, not even dealt with it. So if only a direction is given to him to deal with that petition, that would suffice, Lordship.
you don't want to proceed against this order. Page 97 order.
No, that order has to be set aside, Lordship. They will decide this petition, they
Why
will
should
go
we
ahead.
set aside?
Because they have not dealt with Lordship. Judicial discipline, rules of judicial discipline have been violated.
No, we are not convinced that we should issue a writ in this matter.
Lordship, interim protection to the guarantor was withheld by this honorable court as per direction. In spite of their knowing all the facts, if they don't do it, what else, Lordship?
You have a remedy under the statute. You could have gone there. What
Lordship, but if
what are
that
your
remedy
arguments
is,
as to why the remedy has not been available?
no, Lordship, if that remedy is there, that does not allow them to shred off their responsibility to deal with my petition.
What are your pleadings here with regard to that?
Your Lordship, the basic view is only to not to pay the 50% of the appeal amount, your Lordship. That is why the writ petition has been filed before. your
Lordship will have to consider that my house has been sold off and I don't have anything to pay off. I have mentioned that, Lordship, 4961/2018 writ petition is already pending with this court, so I have to approach this court. In paragraph 34 of my petition, Lordship, page 18. And paragraph 33 mentions that they have not dealt with my petition, Lordship. Equity interest has been created in favor of a property. They would bypass it. That means they would be doing partiality, Lordship.
What is the amount due now?
Lordship,
to
the
bank.
amount due as per my instructions were 3 crores, which was OTS was given at 60 lakhs. After sale of my house. The guarantor had entered into an OTS. The amount decided was some 60 lakhs. They were supposed to proceed against the guarantor, which
Your lordship, guarantor's property is being covered by so many tenants. Even one bank is also there. So there is no bar in the rules before us that we have to proceed only on the mortgage.
We are not inclined unless you show us any authority to say that it should, under the circumstance. You had deliberately avoided going to the authority.
no.
Because
Original authorities I have approached, Lordship. DRT I have approached. Recovery
you
officer I have
have,
approached.
but against this order, you have a remedy under section 30.
But Lordship, this court is already in session of the matter.
This court is in session of the matter because there is no bar for the court not to be in session of the matter
And
after issuance of notice.
Lordship, this court has withdrawn the interim protection granted. After that, the bank does not take any action against him. This is discriminatory, Lordship.
You urge all whatever grounds you want to urge, you urge before the appellate court.
Yes, sir. And Liberty maybe they can file an appeal order.
Lordship, my petition does not even deserve adjudication by the original authority.
You file this appeal before the authority is concerned. Take all whatever grounds you want to take.
But Lordship, that could deprive me of consideration from the original authorities. Because the law is states so that first it has to be considered by the original authorities. Then the appeal authorities will come into picture.
Are you aggrieved by this 97 order or not?
I am aggrieved, Lordship.
Aggrieved. So your grievance under the statute is to be redressed under section 30 by filing an appeal.
Lordship.
You've not gone in an appeal. You have come before this court.
Lordship.
Now we propose to dispose it off and relegate you to filing an appeal if you want.
Lordship, since I have already pointed out that my house stands sold for appeal, 50% of the dues has to be paid. My house was sold off at 96 lakhs and 50% of the dues is 1.5 crores. To be very fair, fairly submitting the facts, Lordship.
Wrong submit.
But under the circumstances, what orders can we pass?
Lordship will peruse page 22 of my petition. In 2012, Lordship, they had proceeded against the respondent number 3. Since there were tenants on the property, they had attached the rent. Now they will keep things pending from 6 to 7 years by discrimination, and my interest amount will go on rising.
Not a single paisa has been paid to us by the rent, your lordship. Because thereafter, all of a sudden, the guarantor has preferred one writ petition.
Page 22, Lordship.
Who
it is-
represents the guarantor?
This is Subhash Singh, respondent number 3 in this writ petition.
Who has
He's a
just now
character.
withdrawn the wakalatnama,
And,
Lordship.
Just before your lordship,
So this page 22, Lordship, it states in the last paragraph, as such, as stated in our letter dated 23/2012, we had to proceed further under SARFAESI Act. And in this connection, we have to inform you that meanwhile, the additional district magistrate Kamrup Metro has already deputed an executive magistrate for taking possession of the secured assets of the bank in your account. In such view of the facts and circumstances, you are once again advised to pay the dues as stated above with accrued interest.
All right, we post this matters on 25th.
Lordship.
In the event we find that there is no representation in the second writ petition,
Lordship.
we'll pass consequent notice.
Lordship.
May
I am for the respondent, my lord, bank in this matter, 67. May I point out one thing, my lord, the petitioner, my lord, in item number 67, they are not appearing, my lord. And there was a specific order while vacating the petition, my lord.
Who was for the petition?
Respondent number 3 in my petition, Lordship.
Respondent number 3 in that petition was the petitioner, he is the guarantor.
Are you representing?
I have similar places, just item number 67. It's just an eyewash, my lord, they are just playing around.
Please inform your client that you are keeping it on 25th. If there is no alternative arrangement made, we are proceeding to decide the matter. Item 7. Right? Commits instructions that by you file whatever application you file within tomorrow, by tomorrow. The prayer is permitted, prayer is allowed. It's also made clear that the petitioner is for making alternative arrangements in case of the that is fixed on 25th of June by which date if no alternative arrangement is made with respect to petitioner in item 7 and respondent number 3 present petitioner proceed past to the part.
If it can be Lordship on 27th, I will be out of station.
25th.
Any other date, Lordship, other than 25th?
26th.
Lordship. Oblige, Lordship.
My presence in item number 67.
Mr. Bahra, it is item number 67.
67 for respondent bank.
For the respondent bank.
Oblige. Oblige.
Getting it for admission item 19.
My lord, earlier opinion, it was being directed to my lord, some data instruction.
I have the instruction, Lordship. I have the instruction, Lordship. Lordship, after receiving the Deputy Commissioner, Lordship, held a meeting, Lordship, with the all police officials, and subsequently the case was registered against this respondents, private respondents, and we have taken some bond from them, Lordship. PR bond, Lordship.
You have released it.
Lordship.
What have you done?
Some bond has been taken from the respondents, Lordship. So they will keep peace, Lordship.
No. You have given Zimmer of the goods to the petitioner.
No. They are coming from against the private respondents, Lordship.
Here, the deputy commissioner is the competent authority matter to allow or not allow those tracks to filled out. And it has been directed on, we have filed the complaint representation before the deputy commissioner and before the police.
So your instructions are from which authority?
Deputy.
What have they said?
Meeting was conducted with all police officers, Lordship. Subsequently, those persons against whom complaints was made, Lordship. This is not named in this application, Lordship. But subsequently, we have taken some bonds from this person's, Lordship.
They are not named. How have you taken for?
But they are respondents, Lordship. In the case, Lordship, they are private respondents. Lordship.
You bring it on record.
Lord.
The respondents will file affidavit.
For the railway part.
Yes.
Item 20.
No, there is a case, my lord, where, my lord, Assam Industrial Infrastructure Development and the right to fair compensation acquired certain property. Now, my lord, the reference has been made without complying the provision of specifically limitation part. Instruction has been sought from on the other side. 3 times, my lord, direction has been given.
No, I have talked to the officers to the Lordship. They will provide, Lordship, because of.
My lord, may I pray one thing, lordship? My lord, my intent is under consideration. My lordship, what happened? The proceeding is going with Amingaon. Otherwise, my lord, the notification says that the Amingaon has no any jurisdiction. It has to be dealt with by the my lord, Kamrup Metro. Lordship, the proceeding may kept because we have submitted our objection now. Next date is, my lord, maybe, my lord, because there is summary proceeding.
What notification?
Well, this notification says the jurisdiction vested to the Kamrup Metro in respect of the whole area. There are 4 districts which has been selected in regard to deal with the reference case.
Why are you supplying newspapers? Why not? Why is it not a part of the pleading?
My lord, earlier we have pointed out, my lord.
Where?
The copy is also there, my lord. Last occasion we have given.
Why could you not bring it on record? Barely legible.
My lord, the Kamrup Metro is there, my lord.
Why should we strain our eyes to read such a copy? Why don't you bring it on record if it is so valuable?
My lord.
List again after 2 weeks. Very instructive. by the respondent. There's summary, evidence for the repetition. 21 also same.
Yes, my lord, same.
2020.
May I pray for date, my lord, after after vacation? Needed.
22nd.
My lord.
My lord, item in item 21, I am appearing for respondent number 2.
Their name has already been struck down, my lord. I think no need.
Item
21.
21.
Item 22.
Yes.
Lordship, we have not received instruction.
My lord, in the last date, Mr. Kikan has taken time.
Has not received instruction.
My lord,
There were some orders passed earlier
yes, yes,
in
yes.
similar matters.
Similar matter has so many orders they passed, so many orders are pending also, my lord. So till they receive the instruction, my lord, no coercive action should be initiated from the department side because it's a heavy amount. So they may take steps for recovery of the amount.
Where is the impugned order?
Impugned order is page number page number 94. It starts from 94. And order portion is at paragraph number.
You come before the court if any coercive action is there.
Yes, yes.
Again, as on date, nothing has been initiated.
No, exam not, but here amount is 1 crore 52 lakhs. So if you give you the amount, the department can make recovery proceedings.
How long do you need time to get your instruction?
Next week, Lord.
Next week. Right, we keep on 25th. 25th?
Yes, my lord.
It's on 25th. At the request of Planning Council for GST. Submit that okay.
M. Morvan on behalf of SK. Respondent number 1.
Yes, for respond. Yeah. List on 25th.
Yes.
Item 23.
Your Lordship, the respondents were supposed to bring instructions on the status of the proceeding.
I have received the minutes of the PLP. Lord. I have the.
No, you don't record.
Lord.
P. Barua. P or R. Barua.
Lordship P. Barua.
P. Petitioner and Suren Goswami for the submit that minutes of the PLPC has been received. The 6 liberty of the court being on record by the
Because
much time.
Lordship, if the minors are such that they have been asked to evict, Lordship, this writ petition will become infructuous, Lordship. In that case, Lordship may dispose of the matter with the liberty given to the petitioners to Lordship to challenge that minor, Lordship, because then the cause of
What
action
does
will
the
remain.
minute reveal? We
said-
got a copy of the minute.
No, Lordship, not yet.
I'll give them.
What does it say?
PLPC decided to evict the shopkeepers.
You serve copies on the petition.
Minutes.
It is submitted that the PL has already taken a decision to evict counsel for that. Yet to receive a copy of the item. Like to buy. Would like to accede the same. What to do with this?
Lordship, otherwise this may remain pending. Lordship, liberty may be given to the petitioners to challenge this matter.
He give you liberty only when he close it.
Lordship, we want to challenge this
Let
because
me
certain
be
aspects may
listed
not have
after
been
2
considered.
weeks, enabling the council. if there is-
Lordship, a date may be fixed. Lordship.
After 2 weeks, no date.
Deeply open.
24.
Well, on last occasion, my friend has told that here the petition is sent for waiting, my lord. The affidavit has been sent, DMD affidavit has been sent for waiting, not to notice. I'm not in this time to find my affidavit. No, there's a notice, and I think the notice has not been issued, they are private response. Well, the illegal construction is going on since. This has to be issued to a private response. On earlier 2 occasions, the instructions were sought for from the GMC GMDA. No, instruction has we have received from the GMDA, my lord. And the building has been constructed as per law by taking TDR, my lord. There is a transfer of rights, my lord. Then the fourth floor has been constructed. And the other part has been regular.
Your affidavit is, how long will you take?
Well, another, most probably today evening, I will get the affidavit of GMDA, my lord. Thereafter, the GMC's affidavit is also got to be filed. Okay, fix it after 10 days, my lord. In the meantime, I will file the affidavit.
Yes.
Well, let it be 7 days after 7 days. Because in the RTA application, this says no construction permission was granted.
The standing counsel for GMDA submit the affidavit are likely to be filed within a period of 1 week from today. The rate or appears for the petitioner is automatically listed after a week. After
A date can be fixed, my
the respondent will endeavor to file the affidavit and straightforward. Matter be listed on '27.
Notice issued to the private respondent because ultimately,
if they get the instruction.
Issue it on 27th. You
Obliged.
just point it out.
25.
The respondents were directed to produce records, lordship, because they stated that they have served notice. I stated that my business was closed.
Yeah. Next week, why don't you have the instructions as well?
Last date also, they were not able to produce, lordship.
Based on 27, enabling the
All right, lordship.
27.
We have filed affidavit in opposition and a copy is also served to the petitioner.
You have filed it.
Yes, Lordship.
Today file an affidavit of the I have received. MS not on airport. Today affidavit has been filed out.
By whom?
Respondent authority.
You filed it today.
Yes, Lordship, because the petitioner was ill and there was notifications for the affidavit. It took time, Lordship.
You are appearing for?
Respondent 1, 2, 3, 4.
Respondents 1, 2, 3 submit. Counsel for respondents 1, 2, 3 submit an affidavit in opposition. Counsel for the petitioner submit. The copies have been served
Yes, Lordship, I have received.
on him. Matter be listed after. You want to file a reply?
No, Lordship.
Matter be listed after 1 week by the registry. The affidavits needed to have been filed. Be connected. The case.
But one thing is that your lordship, the council has misleading me, lordship, on previous date, lordship, he also made commission reportation on the court that he is going to be filed affidavit on that day, lordship. But today affidavit I have received, lordship.
You have received?
Yes, lord, today.
Please speak.
Yeah, the subsequent affidavit has been filed, brother. An additional affidavit is filed, I need instruction for the payment. But the instruction has not come.
Additional affidavit we had filed on 5th of June.
Yeah.
Now it's for the respondents to file the affidavit in opposition.
I have to file a consolidated affidavit.
All right, we, as for the petitioner, respondent.
Hold it.
Respondent, 1 and 2.
Yes, lordship.
2 also.
Two.
Submits that affidavit in 25. Paid for the other time. The other one. If the matter is
Let it be immediately after vacation.
the month of July.
Lordship, if a date
By
was signed.
which time the affidavit taken by the right. It's on 19th.
Lordship. Deeply obliged.
59.
My lord, Mr. Pegu was supposed to get some instruction. In the meanwhile, he has given me an email, and my client has sent an email along with the next of kin certificate to the officer, my lord, and perhaps we are waiting for the instruction. The instruction is incomplete, my lord.
If it is incomplete, why are you showing it? It was complete instruction.
No, after a short date, my lord,
Short date.
after vacation.
The Pegu learned representative. Yeah, 22nd.
The 22nd will be difficult. 24th.
26th.
Of like.
Lordship, my presence may be not. I'm
You are-
for respondent number 5 and 6.
I was going to appear for respond 5.
As stated.
Yes.
Of like.
31.
Which is the lordship. My lord, as per the last order, my lord, the respondent number 8 took time to file the affidavit in opposition, my lord.
Why not? I could not find because even a person is staying in Gujarat, so some difficulties coming in, come down to Guwahati. So I take some time to file the affidavit.
The people. Wait for further time to file. Yeah. Petition.
I'm for respondent number 2 and 3. A. Bora on behalf of Mr. C. Bora.
After vacation, my
on 29th of July.
My lord, in fact, my lord, respondent number 7, in the last occasion, my lord, they had filed a parawise comment directly to the court. It is annexed in the court's record, my lord. PWD, yes, my lord. PWD may be given the direction to file the affidavit, my lord.
If we can't give you a directive file, if their prerogative, if they want to file, they file.
My lord, in the court's record, it is there, my lord.
We'll see on the next.
Lordship, may I pray for a short date? Because
Short date. 27.
27, my
Sorry,
July.
29.
29 July.
29.
Apply.
I think 32.
May I please, my lord? Kindly pay to the last order, my lord.
Lordship, authority take a decision and district commissioner direct the circle officer to take necessary action. order has passed, but
When was this order issued?
yes,
When was it issued?
it is on 14/6, 14/2.
So we record this order and dispose of it.
Lordship?
We'll record this order
Yes, sir.
and we'll dispose of the writ petition.
Yes, Lordship.
Right, let it come.
Order three.
Petitioner is before the court and praying for direction. Order to grant approval on petition. Seeking a direction from the respondent on more particularly to grant mutation of land a specific criteria which he claims to have purchased registered sale deed executed on 12/11/2020. The last order for time of payment. And the government application has provided to the court the order dated 14/6/2024, by which order the Deputy Commissioner Kampur Metro has directed the settle of the 1 year agreement to the needful and take necessary steps at the earliest and number RRG dot 10/2001/3/2002 to convert the grant simple Kiraz Yani Patta as a whole, considering the seal provision of 1956. You have been ordered. Directly proceed for execution of the land as having ordered the path. Directly correspondent. Complete the process of conversion. Complete the process of conversion. In terms of the order dated part by
Respondent number 4, direction 50.
Item 34.
Your Lordship, responded, a series was listed on 12/6/24, in which the respondent have filed common affidavit and the petitioner was given time to reply for the common affidavit after vacation, Your Honor. Your Lordship, so may the later matter may be listed on after vacation, Your Honor.
you want to file reply or not?
After vacation, petitioner has given time to file the reply after vacation,
Where?
your lordship.
By which order?
A series was listed, your lordship, on 12/6/24, in which the respondent had filed common affidavit.
Have you been served with a copy?
Yes, your lordship. Yes, your lordship.
In which matter the affidavit was filed?
Your lordship, I'm not aware of that. Your lordship, I'm not aware of that.
Come back with your instructions next week.
Your lordship, may
Next
kind.
week, next week.
Okay.
Get your instructions.
Item 40.
Respondent is supposed to file affidavit, my lord.
Sorry?
Respondent was supposed to file the affidavit, my lord. I have challenged the demand raised by the state authorities, my lord, in the point of time barred, my lord.
Who's for the respondent?
Al was there and Mr. B. Chaudhary was there.
What is your grievance?
And order at page 48, my lord. It was passed on 4/1/2024, my lord. Whereas the last date of issuance of order was, my lord, 31st of December, my lord. If your lordship will find it page.
You want to say it is time barred?
Yes, my lord, beyond the jurisdiction.
By order dated 25, by order dated 25/2024, respondent, while issuing notice, respondent will participate. However, none represents the respondent purely for the end of justice, matter to be listed again. On 25th,
my lord.
the described
Entry model is there.
entry motor passed early.
Oblige, lordship.
41.
Kindly produce the last order, my lord. There were two companies who were blacklisted by common order, my lord. That matter, my lord. Final order has been passed, my lord. Lord, order can be passed, my lord. That's all.
Yes.
This deferment notice has already been set aside in the other case. So therefore, my lord, in view of that order, I have no, my lord, the order is called for in this present petition. Because the order itself has been set aside. Deferment
The
notice
prayer in
itself
that
has been
petition
set
was
aside.
only for that petition, my lord.
You are representing?
I'm representing the NHA decision, you know. 1 to 3.
Common order was passed.
My lord, there was a common order for blacklisting, my lord.
Where is that order?
Please, my lord.
Page 52.
Annexure 1, my lord.
This notice still has been satisfied. And in fact, this JB itself is one identity. It's not separate.
Petition was, my lord, filed separately. Because the other company was taking lot of
So
time.
this 13.5 has been set aside.
Only qua that petitioner, my lord, because my prayer in that rate was only qua that petitioner.
But the order.
And here also my prayer is only qua this petitioner, my lord, not against the JV, my lord, because I cannot file without instruction of the other company, my lord. If my lord may see my prayer clause, my lord, similar prayer was there also. So identical order can be passed, my lord.
Yes.
Same notice setting aside which has already been set aside again, but that is going
No,
to be
but individual writ petitions are filed.
logically. But the notice itself, but the notice is a composite one, JV is one identity. Two companies become the JV and the JV was given the contract. And termination was issued to the JV. But they have preferred to file two petitions, that will not maintain notices.
The reason being that the other company was taking a lot of time because they had to seek approval of the committee of creditor, my lord, that is companies before NCLT. So we came prior, my lord.
And your lordship, but the
So therefore feedback
Yes, my lord.
with the present petitioner.
No, here is Arminje. Feedback is the petitioner in other.
So come to page 56.
Please. Please, my lord. Feedback in JV with Arminje.
Right. So you've been referred as a
Yes, my lord.
composite.
Both the companies, my lord.
He's right. I don't think a separate order is necessary. It's
Lord,
already been
department
decided.
will again create a problem for us, my lord. Then again, I will have to come for clarification. Identical order can be passed, my lord, because this in this case,
So
my
why
lord.
don't we pass an identical order? We'll simply observe that in view of this order passed.
Yes.
The show cause notice having been blacklisted, notice having been set
Maybe
aside,
cost for this petitioner also.
the same benefit is to be conferred on the writ petitioner. That's all. But accomplished for the crime. This petition is filed in Delhi, the order dated 13/5/2024, wherein the present writ petitioner in wherein one measures feedback infra private limited in JV joint venture with measures Armenge Engineering Management Consultant Private Limited, namely present writ petitioner, been debarred from participating in future projects of NHIDCL that is directly or indirectly from the date of the issuance of the notice within a period of period in accordance with clause 0.9.7 of Article. It is submitted that each of the components of the JVs, namely the Speedback Infra Limited and present writ petition, have approached this court challenging the immune department notification notice dated 13/5/24 by filing separate writ petition. WPC 934 2024 was filed by National Feedback Infra Private. Present writ petition is filed by National Armenge Engineering Private Company, Management Private Limited. Where a coordinate bench by judgment and order dated by order dated 5/6/2024 passed in WPC 934, which was filed by Feedback Infra Private. the impute department is dated 13/5/2022. By the state order, the impute notice was set aside. A similar order is straightforward in the present petition. Since by the same department notice dated 15/5, the petitioner has also heard an account. The respondents are represented by Mr. Keswar, taking up the file. It is submitted that by Mr. Soya that the notice was issued to the joint venture and that having been set aside, no separate orders are required to pass. The councils have been heard, readings have been made, order details were presented. Has been also submitted. By the state order, the department notice dated 13/5/2024. Department notice was issued debarring feedback from private limited in joint venture farming gateway from participating in NHI contract for a period of 2 years in view of contract clause in view of the clause 2.9.7. The operative part of the notice reflects as under para 7. Para. You see that it's quoted by order dated so has already prepared the notice, and the notice was directed against the joint venture comprising of feedback and RBK. That view of the matter, no separate orders are called for the benefit of the benefits conferred by the order dated 5/6/2024 passed in the will have to be conferred to the present petition. Accordingly, the state department notice dated also be deemed to be set aside so far as present petition. Accordingly, disposed of
Lord, my name may be reflected in the order.
Mr. Rajiv Ranjan.
Raj.
You are not opposing in this matter. No, in that matter, you did not oppose.
I had opposed, but that was
because it will be a consent order. Dispose. Yes.
Deeply.
Item 68.
the lordship. Also, the matter pertains to the non-refund of excess PDS refunded from the
My lord, 1 week time may be granted to file over. 1 week time may be granted, my lord. File over affidavit in opposition.
was the last order, lordship. They had thought time for correcting some discrepancy affidavit.
It's regarding the phone number of the deponent, my lord. The paragraph needs to be added, my lord.
Speak louder, I can hear.
With regards to the deponent's phone number, my lord. The new paragraph as per the notification of Guwahati High Court, my lord. that thing needs to be added, my lord, in our affidavit.
You add it,
My lord,
does it require vetting also? No.
No.
It's a direction as per the rule.
my lord.
Add it.
Next week, my lord.
The counsel for the respondent submit that they will file the affidavit within 1 week. There is no interim order.
No.
Matter will be listed on 27.
Obliged.
Obliged.
Mr. Mitra
Lordship.
appears for the writ.
Obliged.
Items 42 to 45.
Page 379. The repeat.
Yes.
Paragraph 14. Merit law. The principle of natural justice having been complied with, the case is taken up for adjudication. I have carefully gone through the record of the case as well as the submission of the notice. I find that the said SCN was for the short payment of central excise duty, including additional duty of excise of NCCD, amounting to rupees 27 crore 61 lakhs 20. By misdeclaring the facts regarding maximum operating speed, that is of taking machine number so and so installed in the factory in violation of the provision of Rule 6, 7, and 9 of Pan Masala Packing Machinery Capacity Determination and Collection of Duty Rule 2008. The packing machine number so and so became operational at the factory of the industrial estate Bamni Maidan, Guwahati, with effect from 18/1/2014, declaring the maximum packing speed of the said machine as 750 pouches per minute. However, in their declaration, that is on 18/7/2014 and 11/12/2014, the said notice has declared the maximum packing speed as 1000 pouches per minute. The machine cannot have two maximum speed. Either is at 750 ppm or 1000 ppm. Operating speed can be fixed by an operator as per his convenience, but the maximum packing speed, which is set by the manufacturer of the machine, cannot be changed. While issuing the purchase order, the said notice is specifically asked for the machine to be used for packing pan masala in 1.5 gram, 10 gram, and 18.22 gram with speed of 1500 to 1600 per ppm and 900 to 1 ppm. As per the invoice issued by the manufacturer, the machine as specified by the notice was delivered and installed. There is no mention of its speed of 750 ppm in any of the purchase document. Before the letter dated 12/6/2015 to the jurisdictional assistant commissioner of Central Excise, intimating him the manufacturing of the machine, the said notice has been operating the said machine with declared maximum making speed of 1000 ppm, about 751 ppm. From 10/6/2015 onward, the said notice declared the maximum packing speed as 750 ppm in form number 1, respect of the said packing machine number 22. I find that the timing of the change of the maximum.
Is the matter where its speed was
Yes.
required to be fixed,
Yes.
which was done and then not accepted by the authority,
Yes.
It was accepted first,
and then rejected.
then their own engineer went there, he himself tested it. And it was accepted, and earlier also the similar so-called notice was issued. And the order was passed, which was went in appeal, and in appeal it was allowed. This is second.
Then let us make an attempt to dispose it of on a hearing date. Subject to convenience. Next week.
Then after vacation.
Why after vacation?
Next week, Thursday, come on, check. In many cases, it will fix.
Did you already, Milord, your lordship has heard it.
I tell you what, because fixing it after vacation, we'll forget everything.
But then I'll file a written synopsis.
First you argue the matter, then you file a written synopsis.
Yes,
Then you will take it up after a while, let the other matters be completed. Thought This will take some time. Therefore, we thought we can fix it on 25 or 27 next week.
And 27.
27 to last 25th, Milord.
Let us attempt on 25th. 25th?
Right.
Let the matter be called up again on 25th of June. An attempt will be made to dispose of the matter the next day.
It already, Milord, your lordship has mentioned earlier that he had, I think, heard in part.
Yes. 25th for further year. For further year.
Items 43, 49 and 4.
Here. I'm taking up 46, my lord, first. A little bit difference is there in each of the cases, my lord. In this case, my lord, because of the construction of the flyover, my house is doing and shop is going to be impacted. Now, my lord, if you look at the initiation of the entire proceeding, it is started with Annexure 5, my lord. May I take your lordship to Annexure 5, page 39. The English translation is at page 38. Yes. It is hereby notified to the public that owing to the construction of flyover at Mission Charali, Tejpur, both the side of the national highway will be extended for the work to be initiated by the PWD. Presently in the said area, on both sides of the national highway, where there is reserved land for national highway, it has been noticed that few people have encroached and illegally constructed houses, etc., and have been carrying on business and other activities and thereby using it. Therefore, the said encroachers are hereby directed to vacate the encroachment from Porua Charali to Balipukri from the national highway and land reserved for national highway within 7 days of publication of this notice. After the completion of the time period, eviction process will be carried out at any day in the said area as per law, and no compensation will be paid at the time of eviction to the encroachers for any loss in the process of eviction. Basically, a notice, my lord, without specifying as to who are the persons who are encroachers, the area of encroachment, and any other relevant details, my lord. Now, my lord, as on this day, it is supposed that the government definitely had made some sort of measurement whereby this kind of notice was issued. In my case, my lord, when we approached this honorable court and this notice was issued, in the year 2023, 2024, they for the first time measured and now blaming that I have encroached an area of land. If I return back to 2022 when this notice was issued, neither in the year 2021, 2022 or 2023, any measurement was carried out. Now, this is the initiation, my lord. Now, the government cannot say that this notice was justified at all. And such kind of notice was also issued so far item number 47 and 48 is concerned. Kindly come to the reply submitted by the government, my lord. Yes. Annexure, my lord, if I take your lordship to Annexure 1, page 55, my lord, affidavit in opposition. Yes. Kindly note the date, my lord, on the right side, 22nd of February 2024. With reference to the subject cited above, I have the honor to inform you that Chetan Pasari, who is the Pattadar of land number so and so, Revenue Village Gotanga Kahdal, has been occupying a portion of land measuring 5 lassa, which is under roadside reserve for national highway.
Therefore, you are requested to take necessary action on the matter from your end. Now, my lord, when the notice was issued to me and it was pasted on my outer wall in 2022, what was the report available with the government? This is nothing but an afterthought, my lord, in the year 2024, that too during the pendency of this writ petition. Now, my lord, there cannot be punishment first, blaming first, and then the offense will be found out. That cannot be, that should not be, my lord. But the conduct of the government clearly shows, kindly look
No,
at the other
you're-
annexes,
You
my lord.
want to submit that initially the notice was stuck.
And that is the
When,
admitted.
when the notice was issued, there was no measure and they could not have found out as to whether you had occupied the area reserved for under roadside, under roadside.
Reserve land, reserved for the purpose of expansion.
But in respect of this 2022, this 22-2, this notice had been 25. What do you have to say?
I have submitted my rejoinder, my lord. Before that, may I say, my lord, that when the notice was initially issued, what was the report available with the government and why such kind of notice was issued? The only objective, my lord, with the government is somehow to reduce the amount of compensation and somehow to take some land so that appropriate compensation is not required to be paid. That is the actual objective, my lord.
No, somehow take land.
Somehow, my lord, just to blame someone, take the land first, and then in the meanwhile allow the person to run for litigation, my lord. In my particular case, my lord, either in item number 46, 47, 48, can the government show that as on 1st of July 2022, there was any sort of report available with it, and on the strength of which the notice was pasted on my outer wall? Now, kindly come to this annexion, my lord, submitted by the government. Is it not an afterthought, my lord?
How do we know?
But they will have to justify, my lord, as to what prompted them on 1st of July 2022 to blame.
You are not asking,
my lord,
for the basis of the finding in this notice dated 22.
I have submitted my rejoinder, my lord, where I have highlighted this also. But before that, kindly look at page 59, my lord, and excerpt 2.
Yes.
My lord, here the kindly see 1, 2, 3, and 4. National highway has been shown, my lord. Roadside reserve land has been shown, and roadside reserve has been shown, and 4-lane flyover acquired land has been shown. Now, your lordship will find that nowhere any sort of measurement has been given. Now, if I point out, my lord, to rules of Assam Land Revenue Regulation, 2 rules which are relevant, my lord, for this purpose.
Who's for the revenue department? Who's for the revenue department?
I am it.
What do you submit?
But I am relying on my affidavit.
Your affidavit on how do you arrive at this notification? Page number 55. Page number 55.
This is on 22
Yeah.
February
This
2024.
means that you have undertaken some measurement. Where are the particulars of the measurement?
That part is right.
Then, on what basis have you issued this notice? And you have 55 read with 59. 59 is the trace map,
Yes, Lordship.
which shows that a portion of the land reserved for the roadside so is under occupation of the petitioner. That is your case.
Yes.
So, how have you measured it to find out that this is the portion of land under it?
I have filed this affidavit on the basis of the report of the circle officer and tradesman.
Where is the circle officer report?
Annexer 1 and 2, Lordship.
Annexer 1 is the notification.
There is a direction, my lord, to bring the entire record, my lord, by this honorable court because of these anomalies.
This is only the notice, it doesn't have the report. There is no report. You don't have to bring it to us. You satisfy yourself and tell us on what basis this notice has been issued.
The lordship may take this matter after petition. I'll file the petitioner affidavit of it. Taking on.
How many affidavits will you file? You said you satisfy us that the order of the certain officer is as per the procedure prescribed under law. There is a trace map,
Yes, lordship.
so there must have been some measurement taken. Now this land, which Mr. Singh, this land which you claim to be yours, on what basis are you making this statement?
I have Jamabandi and sealed it, my lord, which I have annexed as Annexure 1 and 2. And that there is no dispute in regard to that,
No, this portion of the land,
my lord.
part of the land perhaps is covered by the Jamabandi, but this,
The entire land, my lord. May I show your lordship, Rule 23 of rules under the land and revenue regulation, my lord. My lord, Rule 23, rules under the land and revenue regulation.
yes,
Roadside land, nothing in this rule. Have you found, my lord?
Rule 23.
Rule 23, which is known as rules under the land and revenue regulation.
Roadside land, yes.
Yes. Nothing in these rules shall entitle any person to obtain a lease in respect of land within 35 feet from the center line of public road. Any person occupying or encroaching on such land. So it is from the midpoint 35 feet, my lord. Now, in our case, my lord, what this circle officer has been doing, he has been measuring randomly either 50 feet or 52 feet. We are pointing out time and again that it is 35 feet from midpoint. And if you measure from 35 feet, my lord, from the midpoint up to 35 feet, there cannot be any question of any sort of encroachment. May I take your lordship further to Rule 69? This is in case of rural areas, my lord, and Rule 69 is in case of urban. My falls under rural.
69.
69, no new periodic lease shall be issued without the previous sanction of the government for town land within 25 feet or such other distance as may be laid down by special order of the government from the center line of any road. So when we talk about reserve land, my lord, roadside reserve land, either it is 25 feet in case of urban areas or 35 feet from the midpoint of the road, my lord. So in my case, if I ask time and again the circle officer, where from you have been measuring and what is the breadth? So his sketch, my lord, is missing any answer in that respect. Because they don't have the answer where from they have been measuring. And may I submit, your lords, what has been happening on the left side is the headquarters of Score Court. In order to save it, they are curving the entire flyover. Let them do that. But for that, you cannot punish the public at your whims and fancy.
You get the report, how the circle officer has measured,
measures they have
what
taken.
what steps have been taken, notices very out.
All fine on additional application regarding the item number 47, lordship. They have filed an amendment.
That we are withdrawing, my lord. And
you filed a fresh petition.
Right.
Item third. This is 46.
47, this is 46, my lord, I was arguing. Item number 47, we are
In
withdrawing.
47, you are withdrawing.
My lord.
The entire petition.
entire writ petition because, my lord, I have filed a new writ petition.
47. Reported in any 10th case. Next, please. I pending I. Then in 46, you right.
Then item number,
43, 48, 49.
yes, sir.
The
There are other matter.
State Council will, State Council will place before the court the report of federal officer like the land reserve land near the road is found to be under occupation of the in respect to which we
Item. So for item number 48 is concerned, my lord, there is little distinction. Here there is no indication.
Notice dated 2024. Sorry, not notice. Communication dated 2020, 22 to 2024 was issued by the circle officer. The competent authority land acquisition. The item number 46. Yes.
So for item number 47 is concerned, my lord.
47 you have already.
48, my lord. 48. Here there is no allegation of any encroachment. Here the government says that they are going to take over my land. Acquisition.
Same.
It also
Same report
indicated
is with necessary.
subsequently
respect
what
of
has-
item 46, 48 and 49.
But the same letter is not there, my lord.
Doesn't matter. The report of the circle of plastic of the
I am appearing for 2 and 3 in this.
My lord, I am appearing in 49.
49. You are appearing for national
Really, NHA is made party, my lord, that's one more thing. But it's
in the 64. Notice that the thing that the thing is by Mr.
A. Dhanuka.
Nuka. Letter number 2 page.
And for water.
The Hazorika appears for respondent 1.
What?
The Cobra for respondent 3. And the Transport and Highways Union of India.
What a highway.
Huh?
Yeah.
You appear.
64.
Learned. DNP will appear on here.
Union of India. Union of India is.
Within a period of 1 week. No steps. The hard. You have an entry prayer.
My lord. Earlier annexer 8, my lord.
It's not the entry prayer.
Then maybe consider the next hearing.
My lord, there was an
There
was an interim.
their pair lordship. Pair is only for being state of Assam to bring on record by way of affidavit. lordship. And what measures we have taken.
The interim prayer is there, my lord, at page 40. Oh, sorry.
How much time do you require the other matter?
2 weeks lordship.
2 weeks.
The interim prayer may be
Listed on,
considered on next.
My lord, in the meanwhile, no coercive action. Page 22, my lord, interim prayer is there. I have running business, my lord, and there
listed on 22nd, like.
Not.
The Hiru matter should not be returnable on 22nd.
in all the connected cases, my lord, when there is interim prayer, and in this particular case also, which I have withdrawn, my lord.
Yeah.
And there is a running business. And my lord, interim is for namesake. They have been doing all sorts of
You get it
construction
by
activities.
26.
Yes, Lord.
If the next day the respondent will not carry out any demand respect to the existing building without leave of the court.
Highly obliged.
Interim order, extension of further interim order will be considered upon hearing the parties of the next stage.
Deeply obliged.
Deeply.
49.
This was my lord, a report by Deputy Commissioner. Warren has to submit a report.
Genuine.
As to the genuineness of the exhibit B, my lord. Whether report has come or not.
Yes, Lord.
Report has come.
Your
Lord.
allotment has been cancelled.
My
Tag number 369 and 370.
allotment, I was not allotted any land. My lord, I am the tenant. My father was the tenant in respect of the land that the dark number 350.
So the allotment made in the name of who? The original owner.
Yes, that's. The original owner was a tea company, madam. All India tea company. And that land was acquired by the government in ceiling, as a ceiling surplus,
Please
madam.
have a look at this.
Yes. Yes.
Yes.
My lord, actually, here, my lord, the only inquiry was to be made in respect of the genuineness of my Khatian. That has been stated, it is a genuine. It is a genuine. And rest, my lord, it was cancelled in whom I have no, my lord, I have no idea whom it was allotted earlier. I have no idea. Here it is stated that the allotment made in the Dag number 169-370 has been cancelled in the SDLAC meeting held one. Since the report has been submitted by the concerned officer, the land has been transferred from the original LOT. Copy included and the proposal was recommended in the favor of the. I have no idea, my lord. This is second paragraph. I have to go through.
Under the circumstances, then he has to go to the civil court.
No, how? Why? No, civil court nothing to do. Here, my lord, here are various judgment, my lord, there. My rights, my lord. So far, my right prevail upon the other, who are not the tenant. I am the tenant and I am in occupation. That has been admitted in the notice issued to me. That in the notice itself, it is stated in C and D, my lord. I'm in occupation. Occupation of the land. I was not recently. They have occupied, ousting me from the land. Otherwise, I was all along. My father was occupation, and then Khatian was issued. My right is protected by the law. A copy of this name may kindly be given me so that I can properly give reply. I may take the instruction.
Where is the DC letter? 23.5.
My lord. My lord, here, what I have challenged here. B is my Khatian and C, my lord. Dispute arose after serving this notice, my lord. Here in the notice, here are two notices, my lord. The first notice, you are hereby informed that the boundary of the land measuring 2 bigger 2 covered by Dag number 369, 370 of village West Dalgaon, Mauzal, village and grant allotted to the Indra Dhanush Gas Grid Limited shall be shown by the last mandal 157/2020 as per direction of the Deputy Commissioner Office letter such and such. Here, my lord, here the copy 7, my lord. Occupant. Here are other also occupant. We are not concerned here. My name appears here. Abdul Ghafoor.
Sir, you want to get your
Zahur.
instruction, complete your instruction.
Here they have, as a occupant, notice was served to me. Here, my lord.
Now, what do you want?
My lord, here I have my prayer, my lord. That impugn settlement allotment of the land mentioned in the notice dated annexure made to the respondent 5 and 6 should not be quashed and settled. This is my first, my prayer.
On what basis?
My lord, if the allotment, they will say that if they have got the allotment, they say they claim to have got the allotment of the my tenant, my land. Because the law is, your lordship will see the judgment of our High Court that the first, my lord, preference should be given to the tenant, occupant, who is the agriculture. This is a judgment, my lord, the division of judgment, various judgment, my lordship will see. They are not entitled at all. The deputy clearly stated, I am the tenant, my father was the tenant, I inherited the tenancy right.
Where is the finding of the DC?
My lord, there is affidavit. But the affidavit, this is the affidavit. It is page number 61. The amendment made in this affidavit filed by the respondent number 2 are found to be incorrect, my lord, in view of that report. Report said that my Khatyan is a genuine. But here it is said that no Khatyan, there is no Khatyan. And I'm shown as the encroacher. How I can be the encroacher, my lord? A tenant can be termed as the encroacher.
So where is the finding of the deputy commissioner?
My lord, here, here the paragraph 4, my lord. Paragraph 4. The abandonment made in paragraph 3 of the revision are not true and hence the same is denied by the deponent basis that the total land covered by the Act number 350, 370, 38, 49, 48 village West Dalgaon, Mauza, Dalgaon district is found as a Shilling government land as per record. It is there are no record as a Khatian 122 annexure B to the writ petition are found in the office of Dalgaon Revenue Circle. Further, in the land record of the office of Dalgaon Circle, neither father petitioner nor the petitioner were found as a riot in the plot of land and mentioned. It's totally incorrect now in view of the report. And thereafter they say that with regard to the amendment made in paragraph 4 of the petition, deponent basis that the land in question is a government land, petitioner are encroacher of the government land. How I am an encroacher, my lord?
No, what is the basis on which you establish your right?
Yes, my lord. My father was a tenant, undisputed fact. Now report has come. Report shows that my father was a tenant.
Which report?
This report?
Where does it say?
Yes. This report has said, my lord. This report, first paragraph.
Read.
Your lordship will see, in writing a reference to your letter, I would like to inform you that while the affidavit filed by the respondent 2 and 4, just now I read that affidavit, in respect of the above mentioned has been submitted on the basis of the report of circle officer. Dalgaon, verification of the Khatian in the office of District Commissioner Dorong was inadvertently left out at the time. However, upon receipt of the communication and order dated 26/4/20 of this High Court, inquiry has been called and re-examined and record and document available in the DC office Dorong. Upon re-examination of the original copy of Khatian number of the year is found in the record. My Khatian B. This honorable court has directed to call the inquiry as to the annexure B.
But that is with regard to a different DAG number.
My lord?
That is with regard to a different DAG number.
Yes. No. Same DAG number.
No, how can it be?
My lord, Khatian number 22, your lordship will see annexure B.
You are claiming DAG number 369 and 370.
No, so far, my lord, 369 is concerned, I am only in possession. I am not tenant in that house. 370 is Khatian, your lordship will see.
But this is what the report says.
Yes. 370.
You are found.
My DAG. I have clearly stated, your lordship will see my petition, read petition.
So either you rely on the report in its entirety. You can't pick up parts and
No, my lord,
mix and
that
pieces
has
of the
been,
report.
no, that has been, they claim. Other land they have not claimed, my lord. Only that land they have claimed. That is why I have stated. Otherwise, I would not have stated. They claim only that DAG.
Which claim?
Respondent number 5 and 6.
Which DAG number?
370 and 369.
That's right. So that is what they have said. 360, 369 and 370
Yes,
are not found in that Khatian.
370 Khatian.
No. You have
Khatian
not been
land,
able to read it from.
my lord.
In the Khatian,
Yes.
measuring 14 bighas, it is not covered by dock number 369 and 37.
Lordship will seek my Khatian. They may say, I shall give it back. They may say, but your lordship will see the Khatian. Annexure B. The question is whether Khatian is a genuine or not. If Khatian is found genuine, then the question arises whether the Khatian covered that land or not.
Khatian is found genuine
Genuine.
with regard to dock number 350, 37, 38, 49 and 48. What about 369?
No, no. So far 350, 38, 49, 48 is concerned, my lord. You see, and if there no dispute has arisen. No dispute has arisen. No dispute has arisen.
Dispute is only with regard to 360 and 370.
Exactly, my lord. So let them file the revised affidavit, otherwise, my lord, the earlier affidavit, so it is found. The abandonment meaning that affidavit are found wrong.
But in the Khatian, there is no mention of 69.
No, the 69 is not mentioned. I have clearly stated my application, my lord.
Yeah.
In my writ petition, I have clearly stated. Your lordship will see that, see.
I think you need to clarify this position.
370, my lord, in my Khatian mentioned the 370. And
You
other
have a
that.
copy of the petition.
Yeah, the dispute
Can we
arises,
come to page number 25.
my lord.
So I am addressing the government company.
Yes. It is genuine, okay.
Page 25.
Yes,
Read
Lord.
to me.
Three seventy is there,
370 is there.
369 is not.
Yes. In your instruction, they admit that this Khatian, you see, this Khatian contains reference to 350 in the page number 35.
Yes,
Sorry, page number 25.
25.
350, 370, 38, 49, 48. In your reply, in the communication, second paragraph, you find the reference to 350, 370, 38, 49, 48. This is found to be genuine.
Genuine.
So far as allotment in 369 and 370 is concerned, that has been cancelled.
Yes.
So before cancellation, there must be a proper report. The SDLSC meeting has cancelled it on the basis of some report by the
Yes.
circle officer. This will have to be produced. But yes, yes, what are the after- Yes, by the government. Indicating that measuring 40 figures covered by dark 5, 07, 38, 49 and 48 of Julia Farah Khan, the West also. Reflect the name of the petition, the recorded tenant, bracket, here. Further mentioned, allotment may be dark number 369 because cancelled by subdivisional land advisory committee by meeting held on 24, 2020. On the basis of the report, submitted by circle officer. The land has been transferred from the original allotment. And the proposal was recommended in favor of insurance push yet limited, namely respondent number
4, 5,
5 and 6.
5 and 6.
5 and five.
Allocations.
5 presented. Sarah. You are appearing for 6.
I'm for 5.
Well established that the right of a reporting tenant has to be given precedence before the land can be allotted within the respondent. According to government now, place people the report of the circle officer and other relevant reports, the basis of which then allotment with respect to back to 1970 is cancelled by the TRSC. It is meeting allotment open. And as it was recommended in favor of this document be placed before the court the next 8 days. It is still again.
In fact, my lord, the report of the special officer here is at the record.
Where page number?
It's in the report itself. That's the third page. And second page shows that a recommendation of the regarding the instruction from the government, it says that committee recommended the proposal for settlement of government bee firing land measuring 2 bigger fiberglasses covered by tag number 369 and 370 of village Judipar grant under Paschim Dalgaon Moja in favor of Indradhanush Gases Limited in cancellation of earlier allotment made so and so. Now, the petitioner is claiming around 14 bigas or so of the land, my lord. Out of that 2 bigas has been allotment has been cancelled. That 369 is not there in that tag number. Only
That report has to be clear. It's not clear from here. How this report has been, how this communication has been written by the circle of.
Yes.
What are the material?
I think they have to send the original records there.
Original or duplicate, we are not asking. What basis? There has to be some inquiry, verification.
Yes. And there is the history of the land is that, that Indian Tea Company was earlier the owner of the land, madam.
But their names have been found as tenant.
In the Khatyan, yes.
Okay. All right, let them file that report, bring that report before the court.
Item 51.
28th of July.
Yes. Yes.
July, my lord, Sunday, I think.
Huh?
29th of July.
31st of.
Offline.
Yeah.
Please read, my lord. My lord, on the last occasion, I directed the petitioner in person serve us with a copy of the interlocutory application that has been served upon us. I just pray for some time to file an affidavit against it.
Lordship, the interlocutory application is in regarding submission of information under RTI Act by respondent number 4. Surprisingly, on the last order shows that the respondent number 4 was not represented. All the government council is representing from day 1. But in the last order, it is not reflected that the respondent number 4 is not being there. The reply of the respondent number 4 is mandatory, Lordship. So necessary because
What happens to petitioner number 1?
Lordship, he is in Calcutta actually, and his counsel is unwell.
If Lordship permits, Lord, I'll just indicate, Malad, if Lordship kindly takes up the prayer in the repetition. Page 18, F17. Malad, kindly come to page 17, Malad. Page 17. A writ in the nature of mandamus and or any other writ as deemed fit by the honorable court shall not be issued, thereby directing the respondent authorities, specifically respondent number 2, to take into consideration the approval request for initiation of criminal case against suspect officer Sri so and so as sought by the SP Director of Vigilance and Anti-Corruption Assam, vide its letter dated 13/1/2021, and after perusal of the so and so, and basically that is the prayer made in the writ petition, that the Superintendent of Police, SP Directorate of Vigilance and Anti-Corruption has sought for the approval request for initiation of criminal case against the person. That has not been given, so the direction has been sought from this honorable court that the respondent number 2 should act. Now, what the development is, the person to we have filed our affidavit, but subsequent to your lordship's direction, we have sought the clarification from the department, and that has been placed before your lordship. Now the department, after the view of the judicial department, and they have said that the sanction is not required. As the person concerned who is named with the prayer, he is no longer an MLA. No sanction is required. So in that view of the matter, nothing remains in this case. Now the RTI application has been filed, that what action you have taken, that has to be, this honorable court, the petitioner has sought to be and make an executing court, that he will file an RTI application. That reply has not been given. The honorable court will direct the respondent to take instruction.
What steps have been taken now? Person is sanctioned. I mean, in pursuant to the approval request.
Sanction is not required.
Taken by the investigating authority.
Sanction is not required.
I know, but what steps have been taken?
Steps, my lord, the respondent number 1 had filed an affidavit. In that affidavit, as annexure A, they had filed an order dated 10th of June 2023, whereby sanction was refused, my lord. That order.
Lordship, page number 146 may kindly be seen. This is the agency before which I have filed the complaint of corruption against respondent number 5. And now the learned senior counsel submits this court that the sanction is not required. Whereas the reply of the respondent number 4, that is the Vigilance and Anti-Corruption, page number 146, point number A. The competent authority in the government on perusal of the inquiry report dated 25/2023 in connection with the matter of Dr. Durlabh Samoa deemed it fit for closure and passed order accordingly. Hence, the matter rendered infructuous and the copy of the said inquiry report could not be provided. Lordship, this is a very interesting that the government holds the document with it without any authority for more than 2.5 years. Then after they pass a order denying the permission, then when the court asks who is the competent authority, they come to with a new version in this court that their order is in the line that the permission is not required. Whereas the same agency of the government said the matter is closed. If the permission is not required in a matter of disproportionate assets amounting rupees 2.16 crore plus, and the competent the government says the permission is not required, then why in last 3.5 years no FIR has been registered?
That is one part of the story. Here, Lordship is hearing the writ petition filed by the petitioner, and petitioner has to show that what legal right of the petitioner has been violated.
He has filed a complaint.
He has filed a
complaint has not been redressed.
that has been, we have we have filed an affidavit before the honorable court, my lord. And in the affidavit, my lord, ultimately the person to lordship's order, if lordship kindly takes up the order dated 13/3/2024 and 3/4/2024. But 13/3.
There's a continuing sequence from the December 13 December order. From that order, this matter starts on the day when the lordship recorded that the permission has been denied for registration of criminal case. On 13 December, lordship, Mr. Justice Manish Chaudhary has categorically written down the entire first pair of my writ petition. And then after it has been written at point number 3, the writ petition was filed on 14/3/2023. A copy of an order dated 10/6/2023 passed by the Secretary to the Government of Assam, Home and Political Department has been placed on behalf of the petitioner. As per the said order, the competent authority has not granted approval to initiate criminal prosecution against respondent number 5. And now they have taken the complete U-turn that the permission has not been required. And their letter dated 10/6/2023 is absolutely in that line. Because lordship, the problem is the lordship has called who is the competent authority. The competent authority is the speaker. But the matter was pending with the chief minister for over 2.5 years. And when the court has given enough pressure over them to take the decision over them, they conducted a parallel inquiry within a period of 5 days. The inquiry report, 5 days inquiry report shows that no corruption cases against him, the respondent number 5, and accordingly he has been given clean sheet. The agency also replying in the same line. But when your lordship has clearly sought instructions in regards to who is the competent authority, then they have taken the complete U-turn. This matter needs to be examined by the Central Vigilance Commission, and the responsibility of the all involved officers who are lingering in this matter from safeguarding respondent number 5 for last 3.5 years. Lordship, I would also bring your kind attention in regards to the order passed by Mr. Justice Sanjay Kumar Medhi on 26 March 2021 while disposing a writ petition. And that was submitted by the learned this writ petition was filed, lordship, page number 98. This order was enclosed by respondent number 5 in his affidavit in opposition. From this, they is saying that that is a mandatory requirement under section 19. The corresponding page is lordship 100.
Who filed the complaint against the petitioner?
Myself and Mr. Petitioner number 1.
So, Mr. Nag, what is the state?
Lordship, kindly let me place the order dated 3/4/24. 3/4/24. Has your lordship got it?
Yes.
It appears that by order dated 13/3/24, this court has specifically asked the junior government advocate to place specific instruction with regard to the submission made by Sri So-and-so, petitioner number 2 in person, to the effect that the competent authority under section 17A of the Prevention of Corruption Act is the speaker. Though MS So-and-so, learned government advocate Assam has produced an instruction dated 1/4/24 issued from the office of the Joint Secretary to the Government of Assam Political Vigilance Cell Department, including the view of the Judicial Department as well as the Legislature Department, in the matter, it is desired that the said instruction be filed by way of an affidavit by furnishing a copy to the petitioner. This affidavit we have filed for. And in this affidavit, the view of the judicial department and the legislative department is there. If Lordship kindly takes up the affidavit filed by us on 25/4/24. It is filed by the Joint Secretary Home and Political. Joint Secretary Home and Political.
There are two affidavits filed by Home and Political Department, Lordship.
Let me complete.
Two affidavits, but simultaneously we can be.
Let him.
He will get his time. He will get his time.
Where is that affidavit dated?
Affidavit we filed on 25/4/24 by Mr. Jayanta Kumar Bara.
Yes. Para?
Para 2. Para 2, that the Honorable Court by order dated 13/3/24 passed in the instant writ petition has directed the state respondents to bring an instruction as to who is the authority competent to remove an MLA from his office as per section 17A of the Prevention of Corruption Act 1988 as amended. Subsequently, by another order dated 3/4/24, the Honorable Court has directed to bring the instruction on record by filing an affidavit in compliance with the aforementioned orders dated 13/3/24 and 3/4/24 passed by the Honorable Court. This affidavit is being filed. For providing the required instruction in the matter, the political department has sought the views of the judicial department, Government of Assam, and the legislative department, Government of Assam. The stand of the judicial department is at par with the order dated 10/6/2023 at Annexure A to the affidavit filed by the respondent number 1, which states the following. In the instant matter, Dr. Dulab Somua being an ex-MLA, in the light of the decision of the Honorable Supreme Court, Surinder Kumar Bansal versus State of Punjab, it is stated that the prosecution sanctioned to prosecute him for offences under Prevention of Corruption Act 1988 is not required. The same has been suggested with the approval of the LR. This is the view we have annexed at Annexure A in this affidavit. Next para, the Secretary to the Government of Assam Legislative Department by letter dated 1/4/24 has provided their views, stating inter alia that who shall be authority competent to remove an MLA MP in Narasimha Rao case. It has also been decided that there is no authority competent to remove a member of parliament, and the court can take cognizance of the offences mentioned in section 19(1) in the absence of sanction. But it has been stated that till provision is made by parliament in that regard by suitable amendment in the law, the prosecuting agency, before filing a charge sheet.
Right, this has stated no sanction is required.
No sanction is required.
Very nice. Now what
So,
happened?
my humble submission before your lordship is, petitioner has sought for a direction that the matter is pending before the sanctioning authority, and sanction is not given for last 1 year, 2 year for a long period. Now, when the under the Prevention of Corruption Act,
if
sanction is not required.
If sanction is not required,
Lordship,
then the logical consequence.
grievance doesn't
Go ahead with the.
grievance doesn't remain. My respectful submission is that grievance doesn't remain. The grievance in the writ petition doesn't remain.
What do you mean grievance doesn't remain? His grievance is that we are the complainant. First you keep the complaint pending on the ground that sanction has not been granted. Now you come up with a stand by filing an affidavit saying that sanction is not required. So if it is not required, consequence must follow. What step, what reply do you have against that?
But the writ petition as such, my lord, that
Mr. Counsel, not technical. Mainly because there is a prayer, because at the relevant point in time there was a prayer. The sanction was not granted. The writ petition is worded, seeking a direction to the respondents to grant sanction in terms of the provisions of the act. Now, mainly because the sanction is not required, are you submitting to the writ petition itself as the
that is my lord, I humbly submit.
We straight away reject your complaint.
My lord, may I please?
If you want, it will be written an order.
If someone has filed a complaint and the complaint has not been acted upon, 156 for the provisions are there. Provisions are there, but certainly person is very clear.
Filed repeated affidavit. That would have been a ground to object if you had not filed an affidavit. You have filed an affidavit and you don't want to now bring it before the court. What steps you have taken again in terms of the complaints?
But in fact, the investigating authority, they said that we have sought for the sanction. Now the sanction is not there.
Correct.
Lordship can dispose of the matter
Why should
by,
we dispose it of?
as per provision of law. Now they will proceed. The
We are
respondent-
asking you what steps have they taken
But
as
that-
per the
that-
provision of law,
that, my lord,
as
that-
per provision of law.
That my lord, the respondent number 4, I have to take the instruction from the respondent number 4, what action now they have taken. As regard the complaint.
It is a pity that you have come before the court without the instruction. You should have come, you should have had this instruction before you make such a submission before the court.
As regard the grievances raised by the petitioner, I am making the submission. Now, my lord, can I,
Hearing a title suit for a criminal complaint. We are exercising powers under writ.
That's true.
I'm sure you are aware of it.
That's true. That's true.
Then
my lord, the
why are
IA,
you making such a technical submission?
my lord, now the IA has been filed, my lord, to provide the prayer and application to order the respondent number 4 to provide the RTI application.
So who is the counsel of respondent number
Forget
4?
the ITI. We want to know what, in view of the fact that sanction is not required, what steps have been taken.
My lord, I'll place. I'll definitely. place that.
Lordship, my
Vigilant-
prayer number 2.
Vigilance and anti-corruption, that
Lordship, my prayer number 2
I
may
am
kindly
appealing,
be
Lord.
seen, Lordship.
For the Directorate of Vigilance and Anti-Corruption, I am appearing and I'll definitely, what action they have taken, I'll place it before.
Lordship, he is himself saying that the Director of Vigilance and Anti-Corruption sought the approval for registration of a criminal case. And he himself submitting that the permission is not required. How a single counsel can represent two opposite views in a same matter, and then after saying one is, I have the instruction, other one is not. This is only and only the writ court can take actions in this matter, Lordship, because there is a complete
You tell us when you can get the instruction.
My lord, Lordship, give it 2 days time, my lord, I'll get the information, what action they have taken. Other, my lord,
Anything to
this has come up, my lord.
My lord, with
only after
regard to-
the development, after the development.
My lord, we also seek some time with regard to the development because my learned friend is, while placing that sanction is not required. He has cited the case laws of Surinder Kumar Bansal for the state of Punjab and some Sham Bihari Tiwari. These cases are prior to the amendment which has been incorporated in section 19 of the Act. Therefore, my lord, these amendments were in the year 2018, whereby this scope was added to the who is employed or as the case may be was at the time of commission of the offence of crime. Hence, the ratio which was taken.
We are going by the affidavit.
Precisely, my lord, because prior to this, they had submitted an affidavit wherein a stand was taken that sanction has been rejected. So there are two contradictory views. Therefore, we may be allowed to file an affidavit in reply against the same.
How can you file? How are you privy to this information available in the office of the client of the respondent? You are representing who?
Respondent number 5, my lord. The sanction was sought against me.
That's right. How can you be privy to this information?
Against this particular point in law, my lord, whether or not sanction.
File any affidavit if you want.
My lord.
File any affidavit if you want. But how can you be privy to what?
Not that specific information we can have, my lord.
Lordship, now this is clear that the sanction is not required, then the delay should be, accountability for the delay must be.
We are taking.
Let's
We are in session of the matter. Take your card. Let the matter be listed again. Tell us when.
Lordship, keep it next week, Lord. I'll get the instruction. Today is Wednesday, next Wednesday, Lordship.
Next Wednesday, 26. On which date the learned government, senior government advocate will apprise the court the progress, if any, in the complaint filed by the petitioner under the Prevention of Corruption Act, in which the investigating authorities now file the affidavit stating that sanction is required in view of the law given by the authority. Surendra Singh versus the matter listed according to 5 days as status in the private 5. The council for private respondent number 5 is also affidavit. By Bucha. The county petitioner in person. The petitioner in person appears in man represents the petitioner number one. Has submitted that council. This man represents petitioner number one by the next day. The court may proceed to pass orders striking of the name of the and proceed to the retribution permitting the petitioner number
But the affidavit has been filed with the Home Department. The investigating authority is the director or FNO. Affidavit is filed with the Home Department. Home Department.
as per the Home Department. That Home Department is the parent department of the
Yes, sir.
investigating department.
No.
It will be right of the home.
But the IO is different.
Yes, okay. Thank you. Thank you. Thank you.
Right, please, your lordship.
My lord.
My lord, kindly come to the affidavit filed by the respondent number 6, my lord. By the annex the inquiry report, my lord, page 31, starting from page 31. And the operative, my lord, page 32, causes leading to the accident. Page 32.
Yes.
In this, my lord, bottom paragraph, my lord, had appropriate safety preventive measures been taken and had there been regular and proper checking of the line by the owner of the overhead line, the installed electrical accident resulting the death of the victim would not have taken place. Then, my lord,
My lord, ultimately, my lord,
the husband of the petitioner died, my lord.
Who is the owner of the
My lord,
APDCL, my lord.
APDCL, my lord.
Ultimately,
Page
the
31, my lord, serial number 6.
Huh?
Owner, my lord, owner of the electrical installed involved in the accident, my lord. Page 31, my lord. Assam Power Distribution Company Limited, APDC. Then, my lord, contravention, my lord, page 33.
My lord, ultimately, the report says that the fault is on the part of the APDCL. My lord, the APDCL authority is doing a discussion, my lord, and we will take a call whether they will file any appeal or not on the report filed by the Chief Electrical Inspector, my lord.
How long will you take
My
to
lord,
discuss?
2 weeks time may be given, my lord.
Meanwhile, you comply with this order.
My lord, otherwise the instruction they have given to us, my lord, there is a contradiction between the report of the subdivisional engineer, Goalpara Electrical Subdivision, and the report of the Chief Electrical Inspector.
We go by the Chief Electrical Inspector.
My lord,
Subdivisional
my lord,
engineer
there
is your employee.
My lord, we have get this report only after filing the rectification on the last occasion, my lord. Therefore, some time may be given so that we'll take a call, my lord. Whether they will file any, my lord, a discussion is going on, my lord, on this regard.
What is the compensation amount to be paid?
My
Oh,
lord,
that's my lord.
this is a notification, my lord. 90.
What is the point in filing petitions if you have to keep supplying newspapers during the supply?
My lord,
People are relying on such documents, why keep it for? 4 lakhs. When
4
did
lakhs.
when did the accident take place?
my lord, accident take place, my lord, 18/7/2019.
18/7.
Yes, my lord.
So this is prior to the notification.
My lord.
What was the earlier figure?
My lord, but this accident is covered by, my lord, the various judgment passed by this honorable court, my lord. I have given the judgment, my lord. That in the judgment, my lord, accident was occurred in the year 2012, my lord. But the Finding, my lord, best. Paragraph 23, my lord. Accident in the year 2009. Paragraph 23.
You file your affidavit here, APDCL.
My lord,
File the affidavit.
my lord.
Third learned counsel for the party. The report of the electrical inspector has been brought on record by filing an affidavit wherein a false respect to the electrical incident given to the owner of the overhead line, owner of the electrical supply cable / line, namely the AP. Counsel for the AP. Referred to the notification as well as the judgment passed by coordinate bench showing that the amount of compensation required to be paid shall be paid. The counsel for the APCL submits that completed by let's say, let us have it.
My lord.
The month of July, the date
Month, any date.
be fixed by the rate.
God bless.
May I please, Lordship? Okay, here, Lordship, today I have filed an immediate reply, Lordship, to his immediate opposition, Lordship.
Learned counsel for the filed an affidavit, affidavit filed. To be fixed in the month of July.
No, Lordship, kindly maybe before vacation, Lordship, because I am, Lordship, in travel, Lordship. My, everything is taken away by him, Lordship.
What trouble?
Lordship, I was the Lordship, timber shop holder, Lordship. My shop has been sealed, Lordship, without any given, without an opportunity, Lordship.
You are what?
Timber shop holder, Lordship.
Okay.
That is sealed, Lordship.
Let the affidavit be connected.
Lordship, may I pray that
Yes.
after vacation, Lordship?
No, Lordship, it will be trouble for me, Lordship, because there was a file immediate, Lordship, very lately, Lordship. And immediately I have replied, Lordship.
Where is that order? If
So,
you
order is not there, only the lock is given, Lordship, and nothing is there. Only the lock, Lordship. They put a lock, Lordship. In my each Lordship, I have given the photocopy, Lordship, of the lock, Lordship. Page 25, Lordship. Only gave the official lock, Lordship, otherwise nothing is there. And even that is
26.
obliged, Lordship. Hello, Lordship.
May I please, your Lordship? Lordship, 1 more week's time to filing.
2 weeks more further time to file reply affidavit as paid for by the company.
Lordship, there is
Respondent
a-
number 6 to 8, SS from.
Respondent number 1 to 4 on behalf of corporation.
Lordship, there is an interim order.
The order passed early.
Date may be.
Second of August.
May it please your lordship. My lord, 55 and 57 by the same petitioner. One was apprehension that my PSO will be withdrawn, and another is 57. It was particularly withdrawn. And I am before this honorable court. The affidavit was filed by the government stating therein that the review committee has said there is no threat perception against us. And the last order by the honorable court directed that
The minutes of the SSRC meeting is to be produced before the honorable court in a seat cover. As per the law.
You open the seal cover for.
Malak, can I make a small submission, Malak? Every individual has a threat perception differently. Me and
Why are you apprehending?
because there are many criminal cases against me, many threat perceptions are there against me. I've stated there in.
In fact, in our affidavit, we have stated that there are some cases against the petitioner also.
All the cases, the maximum of the cases we have filed an affidavit where the police has stated that they have given
You're a
effort.
You're a very established businessman.
That is why the problem is.
Why don't you go for private security?
Malad, here we are paying for the amount, and Malad, we are.
There is a shortage of manpower.
It is not the shortage. They are saying there is no.
As per the scheme, my lord, and if the threat my lord, emanates from his own conduct, my lord, then in that case, this privilege is not given as per the SOP also.
Let the minute Malad disclose against me what was their threat, whether how could they have decided that there is no threat person. They have filed an affidavit to that. And copy may be furnished to us, my lord.
Why should the minute be disclosed to you?
Well, his name is Bhava Krishna Bormonta.
Yes. What is PRG?
Protection Review Group.
And SSRC?
State Security Review Committee. That is the highest.
Is the different?
Highest level committee, my lord. The
So initially it is PRG.
at the third level, it goes to PRG. Final, it is SSRC. Initially, it starts from the OC, the police station, then SP, then RANS DIG, then PRG, then SSRC.
Where does one get the report of the OC police station report?
But the materials, those were placed before the SSRC, possibly those are kept separately.
So those will have.
These are in the some inputs that they have.
What is TAR? TAR.
Threat assessment report.
In some cases, my lord, there is an interim order. In some cases, interim order is not found. In affidavit, we have stated, my lord, in one case. In affidavit, my lord, we have stated in page, rejoined affidavit. I made a statement also to that extent, man.
So the report says it is not necessary. How is it for the court to decide whether you have a such perception or not?
Not because recently there are many cases we have to file because of their giving threat to me, man, regarding that. And I have been continuing.
Show us parameter and by which the court can decide
No.
between your apprehension.
Only,
and the
only if your lordship permits me, well, this minor may not be given to me, but on that basis, particular some paragraph, if can be punished to us, then we can reply to that. Madam.
There's nothing much here. So it says that on the basis of the threat assessment report, threat perception threat is not there against you. Therefore, there's no recommendation.
Madam, whether those things is on the basis of some records or nothing,
It is on
only
the basis of the threat assessment report is collected starting from the
OC. Whether those were there, my lord, let that be produced before us, my lord. Only by making an affidavit and a statement in a paper that there is no threat perception.
you produce the relevant record on the basis. Because there are two views. Number one is that if the state says that there is no threat perception, we have to go by.
My lord.
Number two, the alternative is that notwithstanding that, there you would like to submit on the basis of some cogent material that their assessment not specific or not correct. And therefore, they are bound to provide. So that you have to provide. But before we decide,
Only thing is, my lord, because we have placed before this honorable court an affidavit there.
see, assuming the threat assessment report is available before us, we'll have to go by whatever it states.
At least, well, that much I can place make a prayer before this honorable court that the reports from the OC and others, that there is no threat perception against me.
See, either the threat perception from the OC level, yes, there is a threat perception.
Yeah.
Maybe the higher authority may, depending on this, may say no, there is no threat perception.
Not in the
Now,
basis
on
of
what basis?
and what basis? Well, that is
How will the
because, my lord,
how will the report decide it?
that is correct, my lord. But, my lord, here
You show us a parameter by which we can take a call on whether this assessment is correct or incorrect.
but we will file an affidavit to that extent, but let them also praise the record before this court.
You keep the records available on the next day if required. There's hardly anything to be put under seal cover. Why have you kept it under seal?
The minor.
What does this minor contain?
Can this minor be, my lord, filed through an affidavit to us?
No, Malad, possibly these are security issues that they are.
What security?
No, these are.
Fact is that his perpetrators, if we may say so, already know that he does not have the cover, therefore he is supposed. According to you, there is no threat perception. Assuming something goes wrong, then you proceed on an investigation which is at times never ending. Now, where does one draw the line that when a citizen comes before the court asking for safety of life and property, the assessment made by the security, the authority, is on the basis of cogent reason?
I would submit that the providing PSO, it's a policy of the government that they have followed the policy.
We are not concerned about whether you provide PSO or not. Safety.
Safety
is up to you.
Safety is a issue. Lordship has indicated that if he feels his personal feeling is that he can go for personal security, private security also, and the safety is a larger issue, but the government at the same time has to have some policy for providing PSO from their side. If the SSRC decides that yes, assessment is there, then
my lord, if I am not wrong,
that is what we want to know.
my lord, if I am not wrong,
on what basis these authorities make the assessment, what is the material which tells them that from these materials we see no threat.
These are,
My lord,
these are not intelligence outputs are also there because these are done by the special branch and this intelligence output, the conduct of the person.
You see and you place it before the.
my lord, safety is not the concern and the policy is there. Let me finish one thing. My lord, I can, without placing the name, my lord, there are businessmen on this place in state of Assam and Guwahati. They are moving around with 2 escorts over there, businessmen. My lord. There are 5 to 10 police personnel
Why are
along
you
with them.
shying away from naming it? Bring them and you tell them that this is.
My lord, they are businessmen basically, my lord.
Now, at one point of time, petitioner also enjoyed. He also enjoyed. Right? PSO was there with him. Now it has been withdrawn. It's a dynamic concept. Malad. He may have said today, tomorrow may not have. I'll malad, call for the material.
Call for the material.
Yes, sir.
Place it before the court. With
Malad.
Roy Chaudhary, you have to.
My lord, I have to think. My lord, I understand your lordship's query, my lord. I understand.
How is it? How is it possible?
Because
say that, yes,
this is a disputed question of fact. They say no, I say yes, my lord. And my lord, let them post the record and we will also think over it, my lord.
Third learned counsel, Mr. D. Nath, learned senior government advocate, terms of the earlier order, it covered the State Security Review Committee report. Minutes. So, it covered was open report, presence of and the report was perused, minutes was perused by the court, and the same was again handed back to the learned government advocate. So we kept up the secret. From the perusal of the minutes, it seems that committee has HSRC has helped that perception which calls for security government. Whereas the learned counsel has submitted that maybe he handed over a copy of the findings. And it says, court does not consider it to the except the prayer. However, in order to justify finding of the SSR, findings arrived at SSR, we permit the government house apprise the court the materials of the basis of which the SSR has helped that material is placed before the by the government sector. So, get the matter again in the month of July.
Exact, my lord, one.
Reopening after the
Date to be fixed by the rate.
My lord.
after the vacation. Yes, sir.
Which matter? 56. Where is that other matter? You make a mention, we fix it. Let these matters be listed or let it be fixed by the next.
After the vacation.
Yes, after, in the month of July.
Okay.
May it please your lordship. Lordship, this is the matter where the bank was directed to seek instructions
Yes.
with regard to the trial court matter. So far as my knowledge goes, lordship, I've checked it online and it says that only the title suit has been restored. But the injunction order was passed in the miscellaneous application. That so once the title suit is restored, the injunction order automatically will get restored. There is an injunction, there was
That
a,
was the instructions you were supposed to get and inform us.
yeah, my lord may please check. The allegation was that we did not have physical possession at the time of auction and thereafter we could not hand over the possession. This was the allegation, ma'am.
My lord, we have attached the certificate of physical possession that was given to us by the executive magistrate. It is on page number 95 of our affidavit in opposition.
Yes. Then how have you given up your possession? Why the possession was given up?
We did not give up the possession.
Uh.
my lord. They were supposed to take the possession, but thereafter the land got encroached by the same mortgager.
And then you obtained an injunction.
We
Lordship,
did
there
not
is-
obtain injunction order. Your
If I
Lordship.
may just clarify the facts, my lord, in this matter. The mortgage took place in the year 2000. The agreement to sell between the mortgager and the third party is of 2007. In 2013, the third party filed a title suit before the learned trial court. In 2014 January, the injunction was granted. 2014 October, the sale notice was published and auction took place. November 2014, I have made the entire payment. In 2016, the respondent bank has written a letter to the deputy commissioner requesting him to provide police protection so that the bank can get the physical possession of the property from the mortgager. So, my lord, even if the physical possession notice is prior to 2016 or prior to the auction, the letter which has been issued after the auction clearly proves that the bank did not have physical possession over the property, but the possession notice which has been produced, that is merely a constructive possession notice. They did not have physical possession of the property. Otherwise, they would not write a letter in 2016 to the deputy commissioner.
Now what is your prayer?
My prayer, my lord, at the time when I filed the writ petition, my prayer was to only refund the principal amount along with interest at the FD rate. But the respondents came up with a plea in the affidavit saying that we are ready to execute the sale deed and hand over possession of the property. Lord, they come up with that particular plea. Now they say that the title suit has again been restored, injunction is there, we cannot give you possession. So, my lord, in my humble submission,
You give the money back. That's the better thing.
my lord,
My lord,
apart
we
from
are-
the money refund part, my lord, there is a decision of the Honorable Supreme Court. It relates to insolvency bankruptcy along with RERA, where the court has said that if the amount has been paid, but the flat is not being handed over within a reasonable period of time, the purchaser or the proposed purchaser is also entitled to compensation and or compensation depending on the facts and circumstances of the case. In my humble submission, Lordship, in spite of the fact that the injunction order was passed in 2014 and the bank came to know about it in 2016,
That's what we
they did not take any steps to get the injunction vacated.
We were not a
They
party
have-
to the suit.
My lord, even if they
So
were
now,
not a
therefore, forget the
They-
land, you give back the money along with the interest.
My lord, with regards to
interest
the
plus
interest part-
compensation, my lord.
We'll look into the compensation. Yes.
My lord, with regards to the interest part also, they themselves initiated a money suit. If they had to come before this honorable court and seek the interest, they could have done so in 2017 itself.
Whatever it may be, it is on the basis of a submission made by you that you want to give back the land.
Yes, because my lord, the title suit wherein the injunction order was there was dismissed for default last year. Thereafter,
We
in
are
this
not
year in
asking you
May,
for the reasons or we are not asking you for the status of the title suit or what they should have done. We are asking you to hand over the property or that particular amount of money.
my lord, we are still willing to
So your
execute the sale
willingness
date.
is not fortified
Provided
by your
pro-
action.
We have provided the injunction order is just, it is the injunction order which is barring us from doing so.
Where is the injunction order? You said it is not there.
It is
Suit
in
has
the
been revived.
it is
Only
in-
the suit has been revived. Where
Only
is
the suit
injunction
is
order?
revived, my lord. No fresh injunction order has
injunction
been passed after that.
my lord, it is the first injunction order is in the writ petition itself in page number 31.
After
But
that, the suit
after the
was dismissed.
revival, I have been.
After
I have
revival
the
of suit,
certified
there is no
copy of the
injunction.
revival order, but no such mention is there of
That-
the.
Before that, the revival of the suit automatically revive the injunction order. Injunction was passed in a mistake case.
Yes, yes. There's no such revival of the injunction order. If the injunction order is not there, is not revived, we are willing to execute the sale date at the earliest.
What
Well,
do you
and
mean the earliest? Give a time frame.
time frame, your lordship, the last time, as I said, we need at least 6 months time.
It is easy for you to refund the money. You refund the money along with the interest to begin with.
Lordship,
Compensation we decide.
otherwise also, the law, your lordship, the bank itself is not in a good health to give the money. There was a lot of anomalies in the bank in 2021. Thereafter, the RBI took over the bank. Now the board of directors is also suspended. It's only the RBI who is functioning the bank as of through an administrator.
Then how do you make this submission before the court that you'll hand over in 6 months' time? Who are you representing?
I am representing the administrator of, particularly the administrator of the
Who
bank.
is the administrator? Who's been appointed as the administrator?
Mahendra Mohan Goswami. Currently, he is the decision making authority for the bank.
It's gone into liquidation.
Not yet, but the situation is such that it might go into liquidation.
So all these submissions that you're making that you want 6 months' time is only to expedite the process of liquidation and then come before the court and say sorry.
No, my lord. No, my lord. That is the play that we made in our affidavit also.
No, madam, we are not convinced with your submission. We give you time till Thursday next to make up your mind and then we'll pass order. Either way. What is it that you want to show? Who's placed this judgment?
My lord, I have placed this judgment, my lord. If your lordship kindly sees G from the bottom in the corner, the column. The object of RERA is to see that real estate projects come to fruition within the stated period and to see that allottees of such projects are not left in the lurch and are finally able to realize their dream of a home or be paid compensation.
You are not purchasing a flat, are you?
My lord, I am purchasing a land and my purpose was to make a home out there. Three people were involved.
This is about RERA, this is about buying.
It is
purchasing a
indeed,
flat.
my lord. I am only on the principle. I'm not on the.
No. The compensation is with regard to home buyer.
My lord, I was also purchasing a plot for
Whatever
making
you
a
are
home.
purchasing a plot,
For
whatever
home, my
home.
lord. For a home, my lord.
But this is not for. This is not for. You're not. You know, opting for an apartment or
My lord,
anything like that. eh?
And my lord, second thing, my lord will kindly
Did it
appreciate.
contain any house on the particular land?
Yes, my lord.
If there is a house,
Yes, my lord. Construction is there.
yes. Then
And the second thing, my lord will appreciate. The bank has been has taken the money in 2014. So that money has been used for business purpose. Once the bank gives a loan.
Here you want 20,
Ma-
27.
27.
Here you want 27. You please take whatever steps you want to take. Otherwise, we passing on. Matter be posted on 27th, enabling MS your name.
Yes, sir.
As the standing counsel for the bank to apprise the court as to what steps have been taken to return the land which was purchased by the petitioner in 2014
14 months.
or in the alternative the amount of money along with interest. So the question of compensation is raised by will also be examined by the Agarwal. It's not
Deep problem.
Please get your instructor to give pass order. They are putting you. We'll post it on some other day.
Subject to lordship convenience, can I take a chance on Friday this week?
Coming Friday. Friday, not possible.
Date subject to lordship convenience.
27. 27. 27th of June.
Next week.
Matters to be taken up for the on 27th. Mr. Todi, for the petitioner, Mr.